He said 12,026.
While keeping this CAV, we had the intent of disposing of the matter. Going through the records, are we audible?
My audible. Respondent
So
number
now we'll fix this matter again in on 4th of December 2026. Yes, madam.
Yes, Your Lordship.
When we kept this CAV, we thought that we'll dispose it of.
Yes, Your Lordship.
But having gone through the judgment that you had supplied to us, we see that a commissioner has to be appointed who will give us a report, and then we will have to dispose it of fixing the liabilities of all the parties. Yes.
Correct, Your Lordship. Yes, Your Lordship.
So we are appointing the commissioner now, and
Your
we'll
Lordship.
have the matter listed on 4th of December.
Yes, Your Lordship.
Please report.
Yes, Your
And
Lordship.
there are some other directions to the police department to take up the matter regarding the press release and all.
Yes, Your Lordship.
That part also report will call for at the end of on the next date of listing. You must be prepared with that one also.
Yes, Your Lordship.
Further, the criminal the trial that had to start regarding the persons who have been identified as per the FIR.
Yes, Your Lordship.
The status of the filing of the charge sheet, etc., is also to be placed before us on the next date. We'll have
Understood,
the
Your
order
Lordship.
by today evening,
Yes, Your Lordship.
and we'll fix it on 4th of December.
Yes, Your Lordship.
All right. Thank you.
Much obliged, Your Lordship.
Yes, tell us.
May I please, Lord? I'd like to mention for listing of a bail, regular bail petition tomorrow, my lord.
Tomorrow. Okay. Is it a special act matter?
Yes, my lord.
May I please, Your Lordship? I have an unusual prayer, my lord, for listing of an anticipatory bail application today, my lord.
Why?
My lord, today, my lord, because my lord, his 10 months son, my lord, he is suffering from critical heart disease, my lord, from by birth, my lord. 10 months old baby, my lord. There is a spot in his heart, my lord. So, my lord, kindly today, my lord.
Is it under the special act? That is
Yes,
the
my
main.
lord, special.
Okay.
Obliged, my lord.
Today.
Today at 2, my lord.
Okay.
Obliged.
Commission, may I mention a matter which is listed as item 79 today?
Ah.
I'm requesting if it can be upgraded anytime post lunch.
We'll try.
Obliged.
Post lunch we'll try.
May I plead, Lordship, Lordship?
Na? 70 ki hul? Item 79. Huh?
Regular bail application, my lord, list on tomorrow, my lord.
Tomorrow. Okay.
My lord. Oblige, Your Lordship.
Is it a special act? Without being a special act, we'll not take it up. Huh?
Maybe. The
Huh?
similar prayer, my lord. Tomorrow. So another prayer, my lord. Item number 20, my lord.
20.
So the respondent, my lord, can you come on next Tuesday, my lord?
At the
I've taken the
request of,
consent of the petitioner, my lord.
at the request of the learned counsel, appearing for the respondents, comma, with the consent of the learned counsel for the petitioners. Place this matter again on
Tuesday, my lord.
Tuesday, 2nd of September.
Obliged, my lord.
May please, Your Lordship, I beg to mention item number 74.
74.
And for appellant, matter will be passed over for a date and fixed on next Tuesday.
At the request of the learned counsel, appearing for the appellant, list the matter again on Tuesday.
Lordship, I
Tuesday will be 2nd, huh?
Lordship, I beg to mention item number 72, Lordship.
2nd of September, Tuesday. Yes?
Item number 72. Lordship,
72.
Before rising, Lordship. Before rising,
Huh?
it matter may be.
We have a list to finish before rising, sir, and we have finished the list every day. Be here, we'll be there. Yes.
I beg to mention for listing of an AB, Your Lordship.
When?
Monday or Tuesday?
Special act?
Yes, POCSO. Monday.
Yes, Monday. Not Monday, Tuesday.
Tuesday.
Oh, not Tuesday can I go? Tuesday will be 1st of September, na? Bondho ase. 2nd of September dibo lebo. Monday did you? Monday.
May please, Your Lordship. Your Lordship, I beg to mention item 69, Your Lordship.
Huh?
We have to take some instructions from the client, Your Lordship.
No. We'll take it up. Yes.
Your Lordship, I beg to mention item number 18, Lordship.
1-8.
1A.
Ah.
Can you matter maybe John, Lordship?
Have you informed the other side? A PP is there. When? When do you want it?
Monday, Lordship.
Monday. At the request of the learned counsel for the petitioner, comma, list the matter again on the 31st of August 2026.
Lordship, I beg to mention item number 33. The CD is not
33.
Yes, ma'am, Lordship.
Hmm.
The CD is not available, Lordship. I pray that interim may continue.
33 CD.
33. 33.
Heard, miss?
So-
Name? Learned Counsel appearing for the petitioner.
ये मतलब from or who? Maybe on 8.
Learned Counsel, Learned APP has submitted that the CD is awaited. List again on
8th of September.
8th of September 2026.
Lordship, item number 16, Lordship. I am
16.
for the respondent and I have filed my affidavit today. It may be called for an attack.
Yes, yes.
Yeah, please, your Lordship. Lordship, item number 21 may be adjourned for the date. It is on legal-
21. Why 3-4 bail petitions disposed of are pending?
Other
Are listed together? Why? Therefore, some other persons or this person only?
other persons were disposed of by Honorable Lordship Sandeep Sharma. These are the co-accused.
Acha. Item number 21, na?
21.
When do you want it?
11th, Lordship.
11th.
11.
At the request of the Learned Counsel appearing for the petitioner, list the matter again on 11th of September. List of TCR is available. Quickly available.
May I please, your Lordship. Lordship, I beg to mention item number 23.
23, yes.
Lordship, kindly adjourn the matter today and fix the matter on 14th September.
14th.
Yes.
At the request of the Learned Counsel for the petitioner, list the matter again on 14th of September 2026. Scan copy of the TCR has been received. Yes.
Please, Lordship, mention for listing for AB, Lordship, for withdrawal.
For withdrawal.
Lordship, AB.
So is it a special act matter?
No, some personal difficulty.
Explain to him. Yes.
Lordship, I beg to mention. May I please, your Lordship? I beg to mention for listing of a criminal revision petition in a motion column, Monday or Tuesday.
Monday or Tuesday. Is it under the special act?
Am I
Something
right, Lordship?
special?
Yes.
Special act is only to get the bail.
The notice does not say so. Notice says only mentions of with. Is it? Notices? Huh?
Alia मतलब
There is a senior bench. Why don't you mention there?
foot number 9.
There is a senior bench available. Only special act matters and those matters which are already listed before this court will be taken up for mention. You have to go to the other bench. Yes.
Right.
Please, Sir, Lordship, with the consent of informants at Lordship, I beg to mention item number 86.
86.
Of supplementary list, Lordship.
Ah,
Lordship, TCR was called for, Lordship, subsequently TCR is not received.
your name?
M. Alam, Lordship.
Mr. M. Alam, Learned Counsel appearing for the petitioner. Learned PP is present. Mr. Mondal is here? No. You have informed him?
Lordship.
Mr. R. Mondal, Learned Counsel appearing for the respondent number 2 has been informed by the respondent number by the counsel for the petitioner. Full stop. The TCR is awaited. List again on 11th of September 2026. Awaiting the scan copy of the TCR. Do you have any interim there? We'll have it on the 9th. 9th, 7th.
7, Lordship.
Too early. Okay.
11.
11th, yes.
I beg to mention item number 24 here.
24, yes.
This matter may be come of 3rd of September here.
At the request of the Learned Counsel appearing for the petitioner, list the matter again on 3rd of September. The TCR has been received.
Highly.
Lordship, I would like to mention item 56. The case diary has not been received.
Item number 56.
Your name, sir?
Jay Sharma. I'm appearing on behalf of you, Chaudhary, sir.
Mr. J. Sharma is present, Learned Counsel is present for the petitioner. The Learned APP has submitted that the case diary called for is awaited. List the matter again on. Then you read it like this. Learned APP has submitted that the charge sheet has been submitted by CS number.
60/2026 dated 5/6/26.
You wanted it when?
So any date.
We'll have it on the
I'm
7th.
currently in interim bail. I would like to extend.
We'll do that, or should we dispose it of today? We'll take it up when the matter reaches. We'll cut out the order. We'll take it up the matter. We'll take up the matter when it reaches. Yes, next.
Lordship, I beg to mention a pending bail application for withdrawal on tomorrow, Lordship.
Is it under the special act, sir?
Yes, Lordship, POCSO Act, and it was listed before your Lordship. I think.
Tomorrow?
Tomorrow, Lordship. Much obliged.
May it please, Lordship. Lordship, I seek your permission to go through the records of item number 84, my lords.
80?
84.
84. Video
But deeply obliged.
permitted. Yes, madam.
There is a notification to mention here. My senior have instructed me just now.
Okay. Okay, allowed.
Obliged.
Side report যদি হেৰি আছে এই CIS ত চাই ল'ব একখন লিখা থাকে ন আন্ডাৰ সেকশন কি
Maybe POCSO is there, Manas?
Ah.
Notice and notice.
Notice and CD.
But Mr. MJ Doctor. Then from page 1 you take 483 Lahorighat PS. Matter involves POCSO. Notice to the respondent number 2 as per prevalent notification. Call for the case diary. List again on 10th of September along with case diary and service report.
I'm obliged.
Steps in 2 days. Huh?
May I please, your Lordship? Lordship, this is a case of theft of foreign liquor. Lordship, 18 days behind the bar, Lordship, page number 10, Lordship, FIR.
Who has
Here-
stolen, they do not know.
Here, Lordship, quantities are given here. RS, Lordship, Royal Steak, 5 case. Royal Salines, Lordship, 5 case.
Ah.
Iconic White, 7 case. Imperial Blue Black, 12 case. After Dark, 5 case. Number 1, Lordship, 6 case. And RC Barrel.
We'll
1
have the,
case.
we'll have the case diary, sir. It was recovered from your place.
All not recovered. Some amount
So
of.
therefore,
liquor
for the
recovered.
recovery to continue, let us have it on the
18
11th
days.
of September.
All right, Lordship, some short date will be given. Already 18 days he is behind the bar.
11th of September.
11th also.
10 days we are giving them.
Obliged, Lordship.
Heard Mr. So-and-so and counsel paying for the petitioner, then you give that part. From page 1, case number and all that. Call for the case diary, list on 11th of September.
May it please to your Lordship. This is first bail application, Lordship, CD may call for.
My lord, UAPA, alia rejected by additional session judge. Whereas, it's maybe appeal live before DB.
Appeal will lie before the,
Before division bench. There is a judgment, I will provide after some time.
after some time?
Obliged, Lordship.
It after some time.
Once rejection,
It after some time. We also remembered something like that.
May please, Lord.
Ah,
POCSO is there, my lord.
okay. You are Mr.
H.A. Ahmed.
H.A. Ahmed, learned counsel for the petitioner. Then take from page number 1. Since the provisions of POCSO Act are involved, issue notice on respondent number 2 as per prevalent notification. Steps by petitioner by tomorrow. List again on
14.
Huh?
14.
14th of
From
September. Huh?
From Hategaon.
From Hathi.
But notice 11.
11. Have you done it?
Obliged. Item 5.
Mm.
My lord, the petitioner is behind bars for, my lord, 6 months, 5 days, my lord. The background of the case is that, my lord, the petitioner was earlier arrested, my lord, on 25/5/2020.
Dacoity.
No, my lord, one second, my lord.
Attempted dacoity, huh?
25/2021, he was arrested, my lord, in connection with the present case, my lord.
25/5/2021.
Yes, my lord. Thereafter, he was released on bail, my lord.
Mm.
He remained in jail for 27 days, my lord. I have annexed the bail order that is on
Okay.
page 16, my lord.
Ah,
Subsequently, my lord, the case records were transferred to the Court of Session Judge, my lord, and he entrusted an advocate, my lord, to represent him. In 5 or 6 occasions, my lord, the counsel represented him, my lord. In one occasion, my lord, the counsel could not appear, and he also remained absent due to his illness, my lord. And on such occasion, my lord, NBW was issued.
When, date?
My lord, page 20, my lord, on 6/2/2026, my lord. He could not appear, my lord. And
Ah.
NBWA was issued, my lord.
Ah,
And he has been arrested, my lord, and since then he is in jail.
when was he arrested?
My lord, 21/2/2026.
Otherwise, you were on bail.
Yes, my lord, I have annexed the bail order, my lord, page 16. All the other co-accused are allowed on previous bail, my lord.
And all the other accused were also appearing.
My lord, only one
You were
occasion.
the only person who was doing, still continuing to do business outside.
This is not NDPS case, my
Then
lord.
what is it?
My
Oh,
lord,
dacoity, yes.
yes, my lord.
Ah, it's the same business.
Making preparation for dacoity, my lord. However, my lord, since he was arrested, my lord, for 6 months,
Yes, sir, others are on bail.
I think my
He
lord,
has
can
been
be
behind bars from February due to his absence.
only one occasion, my lord, he was absent. my lord.
We'll allow him.
Yes, my lord.
Heard, Mr.
SS Ahmed, my lord.
S.S. Ahmed, learned counsel appearing for the petitioner. Also heard the Mr. Parashar, learned APP, full stop. The petitioner is an accused in Sessions case number 87 of 2024, pending before the court of the learned additional session judge within bracket FTC Shri Bhumi, full stop. The learned counsel for the petitioner has submitted that the petitioner had been granted bail during the trial period by order dated
21/6/2020.
21/6/2021, full stop. How many days did you remain absent in between?
Only one occasion, my lord.
We'll record that.
Yes, my lord.
The learned counsel for the petitioner has submitted that the petitioner had remained absent during the trial only on 6/2/2026, full stop.
And on that
And
day,
on the same day, non-bailable warrants of arrest had been issued against the petitioner. Full stop. The learned counsel has submitted that the counsel engaged by the petitioner to represent him in the trial also could not attend the court on 6/2/2026, and therefore none represented him during on 6/2/2026, full stop. He has submitted that the petitioner had been diligently participating in the trial, and since he is behind bars for the last 4 months for one occasion of absence, comma, this court may consider granting him bail since the petitioner undertakes to participate again in the trial proceedings as and when dates are fixed, full stop. Learned APP has submitted that from the records, it appears that the petitioner had been granted bail after he appeared after receiving summons, but the date of absence on 6/2/2026, he was on NBWAs were issued. The petition does not contain the proceedings of the earlier dates to show the presence of the petitioner during the earlier dates, full stop.
my lord, in the
I
earlier dates, my lord,
I have
his
considered this.
counsel was present, my lord.
I have considered the submissions made. The learned counsel for the petitioner has submitted that the petitioner was either present in person or was represented by a counsel on all the other dates. This submission has been made on the basis of instructions received from the petitioner. Yes. We are recording it.
Yes, my lord.
He was either personally present or he was represented
He
by
was
a counsel.
represented through his counsel, my lord. He was not present, but his counsel was present. But only one occasion, he and his counsel both were absent and
Okay.
NBW issue.
No, he was always represented either through either personally wala card dijiye. Huh? Okay, you write down, I'll make the correction. Full stop. Having considered the circumstances of the case, I deem it proper to allow the petitioner the privilege of a bail since NBWs were issued only on his absence of representation on 6/2/2026, full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees. What was the earlier amount?
40,000, my lord.
Earlier 40,000, huh? 40,000 with one local surety of the like amount. Stop. To the satisfaction of the learned trial court, full stop. Learned trial court shall be at liberty to impose such other conditions on the petitioner as may be deemed necessary to ensure his participation in the trial, full stop. It is made clear that in the failure of the petitioner to remain personally present on all the dates now fixed, which will now be fixed by the learned trial court for the trial proceedings. And in the event no reasons are shown for absence, if any, comma, the bail granted today shall be liable to be recalled. Bail petition disposed of. If he remains absent or without representation on the next day,
Hello.
it is being recalled.
I'm grateful.
Yes.
May I please, your lordship? Lordship, the seizure is of around 1.131 kg of yaba tablet, yaba. And the seizure list is at page number 14. It was seized from my co-passenger, Mufizul Rahman, from the backpack of he was carrying. I and the other co-accused were traveling along with him. And the interesting part in this case, the seizure was done at around, if your lordship take a look at page number 16, 2:40 a.m. But I being a lady, no permission from the magistrate was taken under section 43(5) of the BNSS. And today is 213 days. I am behind the bar.
So ladies are allowed to carry around yaba tablets?
No,
during the
I'm
night?
carrying. I'm not carrying. My co-passenger was carrying. I was traveling along with him. And from the seizure list, it was clear that the backpack was along with the co-accused Mufizul Rahman, not by me. If your lordship turn to page number 16.
Yes, sir. Nighttime.
Just take your lordship to one paragraph in bail application 2468. 6 and 7 both are,
Connected.
We are on 2468, yes.
lordship will come to paragraph 7 at page 5. So petitioner who is a plumber by profession earning very low
That is a
was
typographical error.
given enticement.
Typographical error.
Enticement by the co-accused person so and so, and that if the present petitioner so and so travel with him to and from Coach Bihar and Silchar, they will get a wholesome amount of money. Therefore, these three persons, that is the person from whom it has been recovered, then the petitioner in item 6, petitioner in item 7, they are connected, lordship.
They were traveling as a family. So now they should stay as a family till we have the case diary.
Yes, your lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. RKD Chaudhary, standing counsel NCB. Learned senior counsel,
Deputy SGL. There is the
deputy SGL, learned and senior advocate assisted by Imam, learned counsel for the NCB, full stop. Call for the case diary, list again on
trial period. Oh, it will be
Trial court
the-
record?
No, it will be the case diary. Let it be after 2 weeks, lordship. In the meantime, I will also file my observation.
14th,
That is fine, lordship.
14th of September. Yes.
6 and
7,
7.
both. Item
6
7.
and
also.
7 both, huh? Separate orders. You give separate orders. First paragraph will be different. Application under so-and-so, connection with so-and-so, and petitioner name will be different. Huh? Yes.
So,
Deeply opposed.
Item 8. Yes, sir.
Please, your lordship. 483 application, my lord.
Huh?
483, my lord. My lord, what happened? I take your lordship the FIR, page 16 is the FIR.
Hmm.
On 7 to 26, 2 persons who were traveling from in a Arunachal bound train,
Hmm.
and they were pulled down by the RPF men from a train, my lord. 2 persons. And from their position, allegedly recovered 13 kg, 750 grams, and 13 kg 650 grams. And they were arrested, and charge sheet was filed, and charge was out of frame. But interestingly, my lord, charge sheet was given at 2023, my lord. 20 B2 and C29 NDPS Act. But without any mention in the FIR, in the charge sheet, that they were jointly operating the matter.
That will be a matter of trial. That will be a matter of
No.
trial.
My lord, our own High Court as well as the Supreme Court, in a series of judgment, yes, the must be, otherwise it is a, if it is 13 kg of fuel, it is a intermediate quantity. but it has been clubbed as it is a commercial quantity, more than 20 kg
Both were carrying separately.
separately.
Both were carrying some amount separately.
Yes, some this ganja separately. They are traveling separately.
Ah.
And my lord, if they are jointly operating that doing, then there should be an averment in the affair in the final report. But it was not there. And learned court below also has not considered this matter. And we prayed for bail. My lord, 200 days above we are behind the bar. 202 days. We pray for bail, my lord. And may I place this judgment of our own High Court Division Bench, referring of the Supreme Court, my lord.
At this stage, only PCR might be called for.
Scan copy of the TCR we'll know from there.
ঠিক আছে না লাগে ওর স্ক্যান করবো ডিরেকশন my lord,
Have a look into that aspect, Mr. Parasha. It doesn't reflect anywhere.
13 kg.
13 kg, that is intermediate quantity.
13 is intermediate. 13 each should be intermediate each.
The IO has clubbed together.
And it is
But-
not said they were traveling together. One was with two backpacks on the door. The other was sitting somewhere else with the
Yes.
bag.
Though.
No, one sentence. One identified the other, or both of them were standing
But
together.
in case of intermediate quantity also, such seated case.
Yes, intermediate quantity.
We will ask for the case diary for the time being, sir.
But it
Even
is that,
in
my lord, ultimately, even if trial also, if this jointly convicted, but
below 1 kg of ganja,
Seated under 29.
we presume it's a good evening for them. More
Yes.
than 1 kg, maybe intermediate.
Yes, yes.
It may be a
1
horrible
kg is
evening for
more
everybody.
more quantity.
Heard Mr. S.C. Biswas, learned counsel appealing for the petition. Also heard the learned APP, full stop. Petition under section 483 in connection with Rangapara case number, page 1 and 2. Call for the scanned copy of the case diary. List again on.
7th possible, but
It will not come.
from Tejpur it will come.
7, 8, several number of cases already
Late.
reached,
ঠিক আছে, আপনার সুবিধা মতো দিও।
On 9th?
9.
9th, on 9th of September, full stop, Mr. S.C. Biswas has contended that there is no allegation that the two persons were traveling together to be imposed the joint liability of carrying commercial quantity of ganja.
একদমটা নিয়ে নেয়। নিয়ে নাও, ঠিক আছে।
Make me the my lord, in between, my lord, intermediate question, diary will be required, I think. 30 days today, my lord.
Charge sheeted, no.
No,
not
pending, my lord.
TD. Okay. Same order, Mr. N.J. Dotto, learned counsel appealing for the petitioner. From page 1, you would take. Petitioner was arrested on 29/7/2026, full stop. Call for the case diary. List again on 9th of September 2026.
I'm of that.
May I please observe? This is an application under section 483 in connection with PS case number 83 of the 2000.
Yes.
Lordship, under section 4 of the PROCEEDINGS, your lordship.
Okay, heard Mr. Roy, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, application under 483 in connection with so-and-so. Petitioner was arrested on 21/7/2026. Since the provisions of the POCSO Act are involved, issue notice on the respondent number 2 as per prevalent notification. Petitioner to take steps within 2 days. List again on a call for this case diary. List again on 14th of September.
Can it be on 11th of September?
11th.
Yes, sir.
Possible? 11th of September.
483 application, Your Lordship. And most importantly, Your Lordship, two of the co-accused has granted bail by this honorable court, Your Lordship.
Huh?
Yes, Your
They
Lordship.
must have told us they brought the cows.
Okay.
And now we are coming up with an FIR saying that it's a stolen cow. Yes, let's see.
On 21st of August, Your Lordship, two co-accused has been granted bail.
When were you arrested?
Till date, Your Lordship, 42 days, Your Lordship. On date of arrest is 16/7/2026, Your Lordship. 16/7/2026, Your Lordship.
Same PS case.
Yes, Lord.
Kindly give him a copy.
Yes, Lord.
Yes, you are Mr. S. You are S. D. Roy, huh?
Yes, Lordship.
S. D. Roy, huh?
00.
So, Mr. Same case, others have been granted bail. Yes, madam. This judgment, I made the corrections. Same case, same FIR, same order.
Lordship.
Disposed of.
Detention की only negative.
42 days.
Earlier 36 days.
Highly Lordship.
6 more days. Huh?
Highly Lordship.
My lord, yes. The judgments of the honorable court,
We'll have it tomorrow. Let him go through.
On Monday, Lordship. We'll
Monday,
produce the
at the request of the learned counsel for the petitioner, list the matter again on 31st of August 2026, full stop. The learned counsel for the petitioner shall have his instructions as to whether the present bail application is maintainable in view of the judgment of this court in
BA number 1727/25 dated 5/12/25. And another is specific is BA 3410/25 dated 9/12/25.
Obliged, Lordship.
9/12/25.
76 can it be after sometimes, man?
Huh?
After sometimes, man.
But the date will remain the same.
No, my lord, my senior, he wants to appear with this.
Okay, number of days in custody will remain the same.
Same, man.
After some time.
Kindly, man. I'm sorry, man.
11. Huh?
My pleasure.
Ah,
Worship, this is an anticipatory bail application, my lord. Petitioner is the father of the accused number 1.
hmm.
Lord, whole allegation, my lord, against the accused number 1.
Ah.
Kindly see the FIR, my lord, at page 11, annexure 2.
You are accused number 2.
Yes, my lord, I am the father. My lord, may I read the FIR? My lord, interestingly, my lord, FIR lost after about 1 month.
When the husband and wife are living peacefully,
Yes.
father-in-law and mother-in-law should stay
Remain
away
silent,
from
ma'am.
petty fights.
My lord, the problem arises, my lord, since the marriage, my lord.
Maybe you should have
Since the
said-
marriage. My lord, I was against.
Yes, we'll allow him to appear, Mr. Parasar.
My lord,
At the ill advice, the son beat her up.
injury as per the.
No, that is accused number 2.
Yes,
He is accused number, that is accused number 1.
yes.
He is accused number 2,
Yes.
the father.
Yes.
We'll allow the father, huh? Heard Mr. K.M., you are Mr.
K.I. Mazumdar.
K.I. Mazumdar, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parasar, learned APP. This is an application under section 482 in connection with Fakirganj PS case number so-and-so. The learned counsel for the petitioner has submitted that. What is your name?
My lord, Mokhlesur Rahman alias Abdul Mokhles. First phrase, my lord.
Okay. And the petitioner, learned counsel for the petitioner has submitted that the petitioner is the father-in-law of the informant.
Yes.
of the informant, and the allegations in the FIR are to the extent that the present petitioner had given ill advice to his son, due to which the son of the petitioner had allegedly physically abused the informant. Full stop. Call for the case diary list again on 23rd of September 2026. In the meantime, the petitioner, namely so and so, shall appear before the investigating officer of the case and participate and cooperate in the investigation. In the event of his arrest, he shall be released on bail on furnishing a bond of rupees 10,000 with one local surety of the like amount to the satisfaction of the arresting authority. In the event of the arrest, I have written at the word prior to the next date of listing.
Within specified period, Malord.
He will,
Within
petitioner will appear before the IO on or before 7th of September 2026.
I love this.
Item 12 progress.
12 key. You have to mention also.
No, I am appearing.
Huh?
Not motion, my lord.
नहीं 12 का मैं मेंशन दिखवा नहीं करूँ. Huh? 12 was mentioned. Why नहीं कितना?
Motion not
Motic issue. After something. After something. 13.
May it please your lordship. Herein the instant facts are as such that your lordship, the informant's son and the petitioner number one were in a relationship, your lordship. And both the parents of the petitioner number one and the informant were not very supportive about the relationship, your lordship. And subsequently, the petitioner number one did not pursue the relationship. And following which, what happened, your lordship, the informant's son was found in a hanging position, your lordship. The FIR is at page 14, your lordship. If your lordship.
He was found inside his own home.
Yes, in his own premises, your lordship.
Inside his own home.
in the case of 108.
Huh?
103 will not come.
They may go and appear at least. Huh? Let them appear. Heard Mr.
J.K. Roy, your lordship.
Learned Counsel appearing for the petitioners. Also heard Mr. Parashar, Learned Counsel appearing for the Learned APP. Full stop. Application under 482 in connection with Hajo PS case number so and so. The Learned Counsel for the petitioner has submitted that the son of the informant had been found hanging inside the bathroom of his own house.
Yes, sir.
And the informant in the FIR has raised apprehension that due to the love affairs arising between the son of the informant and the petitioner number one here in comma, the death of the son might have occurred. Full stop. There are allegations in the FIR indicating that the informant suspects that the son of the petitioner, son of the informant had been murdered and hanged inside the house of the informant. Full stop. Call for the case diary. List again on 24th. 24th of September 2026. Full stop. The petitioner number 1, 2, and 3, namely so and so, so and so, so and so, shall appear before the investigating officer on or before the 8th of September 2026 and participate and cooperate in the investigation process. In the event of the arrest of the petitioners number 1, 2, and 3, they shall be released on bail on each furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating authority. Full stop. The petitioners shall not in any manner interact, threaten, or coerce the informant or his family members during the period of their bail. It was very dilu, 24th of September. Transit bill, sir.
Transit bill.
Lord. Why did you not appear when you received the notice?
I have received it on 16/8, madam.
You have received the notice on 16/8
16/8.
and you are required to appear when? Where is that
7 days
notice?
From the date of receipt.
Huh?
In 7 days from the date of receipt.
16/8.
To 23/8.
So why did you not go?
I am apprehending, my lord.
Huh?
So I am appealing, my lord. I am ready to.
Where is the notice?
At page, my lord, 53, my lord.
53.
My lord. I am appealing, I am cooperating.
Only to appear before the court of jurisdictional court and to, huh?
My lord. Well, I have to, my lord, collect the bank statements.
Received on 16/8.
15/8, my lord.
Okay, and what do you have to collect?
Some other documents of the farm, which is.
I do not know. I'll give you 21 days.
My lord, 30 days, my lord.
Huh?
30 days, my lord.
Okay. 30 days. This is disposed of. Transit bill granted. You'll have it in the afternoon.
Highly obliged.
এই তিনটা যে একেলগে আছে সেইকেইটা আফটার লাঞ্চ লাঞ্চ বুলি নকয় ৰিচেছ বুলি কয় ন আফটাৰ ৰিচেছ yes
May I please, Lordship? Lordship, may kindly find the FIR at page 10, type copy of page 12 also.
page 12
Page 12 is the type copy.
Hmm.
Allegation under section 118, subsection 2, Lordship. Allegation of grievous hurt. But Lordship, may kindly, if Lordship may kindly goes through the FIR,
just call me by the way
it's a quite vague FIR, Lordship.
what is vague about it he was attacked with sharp weapons
Sharpen, what weapon was used? Where he got injury?
oh
What
FIR
kind
did
of,
not
nothing mentioned, Lordship. Lordship, may kindly see. And actual
brother
fact-
became unconscious
Yes.
he was found lying in the street
How he was injured, nothing has been mentioned. Lordship, may kindly.
something happens outside the court now I will also only know that someone fell down and he was injured god forbid but someone fell down and injured
Lord-
how will I know
Lordship, Lordship, may kindly to paragraph 4 of my petition. I have stated the actual fact.
huh
Paragraph 4 of my petition, actual fact is
what
there.
is the other FIR
Other FIR, Lordship, that we lost that FIR. They are
when 7 8
the victim actually attacked us on that day. Therefore, we lost FIR with the police, Lordship. That FIR, Lordship, may kindly see page 17. This is our FIR.
Date 14.
Actually, there is a business rivalry regarding a breach.
On 7/8, the injured attacked you.
Yes.
And on 14/8, you attacked the injured.
No, no, Lordship. The FIR, they lost FIR on 6th, Lordship. Lordship, may kindly see their FIR. Their
Eh?
on 6th, vernacular, Lordship, may kindly see at page 14, 8/8. They lost FIR on 8/8 and that was registered on 14/8. Their FIR. And we lost FIR on 7. On the day of incident, Lordship.
There is a report that there was a fight. Call for the case diary, huh?
There was a quarrel, Lordship, that is a report. And Lordship, may kindly come to paragraph 4 of my petition, everything will be clear. That's it. There is a rivalry. The victim actually assaulted the petition number 1 and 2. Then villagers came, they stopped and they assaulted this person. That
He was assaulted by someone.
other person, not.
You are
by
not
me.
from the village.
I am from the village.
Villagers did it, you are from the village.
They saved me, us, Lordship. They saved us. Petitioner number 1 and 2 was saved by the villagers, Lordship, from them. They will appear, Lordship, they will cooperate with the investigation. If they appear, it will help the investigation, Lordship. That may be done, Lordship. They will appear, they will cooperate.
Without injury report,
Huh?
Lordship is always there.
incident is there,
No, we are apprehensive on page 15.
Yes. লগত মারপিট হওয়াটো সত্য মারপিট how the মারপিট happened lordship I have already stated lordship that the villagers assaulted lordship
Jogi Upa. 7th of September.
lordship petitioner number 3 is a cancer
The-
patient lordship petition number 3 is a cancer patient. He is not able to attend doctor lordship he has to go for PET scan I have stated lord the
Okay,
documents I have
Mr. So-and-so Learned Counsel appearing for the. You are Mr. M.I. Hussain.
Hussain, lordship.
Learned Counsel appearing for the petitioner also heard Mr. K.K. Parashar, Learned APP full stop, application under 482. Jogigopa PS case number 131 of 2026. Learned Counsel for the petitioner has submitted that the petitioner number 3 is a cancer patient and is undergoing treatment for the same full stop. He has therefore prayed that the petitioners may be allowed the privilege of a bail since the FIR or the report of the police does not reflect the extent of the quarrel. Full stop. The learned APP has sought for accommodation to produce the case diary and the medical report of the injured person. Full stop. Call for the case diary list again on
On 10th.
on 10th of September 2026.
lordship may I pay
It is provided that in the interim, it is provided that the petitioner number 3.
4 also
shall-
lordship he
What is 4?
for 4 also he is the father of petitioner number 1 lordship
So,
a 50-year-old man is the father. Actually,
50
quarrel.
50-year-old man?
I am not an age, but quarrel between petition number 1, 2, and the informant's brother. So,
The
lordship.
report says so.
Yes, lordship. Quarrel between petition number 1, 2, and the informant's brother.
Where is it?
So, lordship may consider petition number 4.
Okay, in the interim, it is provided that the petitioner number 3, who has been submitted to be a patient suffering from cancer, and petitioner number 4,
It's
whose name does not reflect in the police report,
yes, but the police report there is no name.
whose name does not reflect in the police report, and who is the father of the petitioner number 1, who is alleged to have been involved in the fight, shall appear before the investigating officer on or before the 2nd of September 2026 to participate and cooperate in the investigation process. In the event of their arrest, the petitioner number 3 and 4, namely so and so shall be released on bail on furnishing bond of rupees 10,000 each, with one surety of the like amount each to the satisfaction of the investigating officer. Full stop. It is made clear that the interim protection to the to the petition number 1 and 2 has not been considered by this court at this stage.
Deeply obliged. Item 22.
কিমান লৈকে গ'ল এতিয়া? এইটো কিমান নম্বৰ গ'ল?
May I please your lordship?
Service report complete, my lord.
Service report awaited.
Awaited, lordship.
Complete.
Complete.
Oh, sorry, not complete. Not
Awaited,
complete.
lordship.
Awaited, sorry. As per office.
Lordship, my senior may take information about the service.
I'll take inspection. madam.
Third. On third, either they appear or we appointed amicus.
Lordship.
If we keep it for too long, then the appointment, otherwise, when were you arrested, madam?
Lordship,
25/3.
We have three substitute case.
List again on the 3rd of September 2026, allowing the learned APP to have his instructions on the report of service of notice on the respondent number 2. Scan copy of the TCR has been received.
obliged, lordship.
24.
The 24 টিক মাৰি থোৱা আছে দেখোন, এইটো হেৰি নেকি? 24 টিক মাৰিলো কি? একজন হৈছিলে 23, 24 দুইটা। 23, 24 দুইটা একজন আছিলে। কনফাৰ্ম কৰি ল'ব, নহ'লে পিছবেলা মাতি দিব। একো নাই, একো ইমান দৌৰা দৌৰি নাই। এশটাহে
Lordship, today speaks for medical report, Lordship. Most probably
Yes, for the medical report.
yes, tell us.
collected and produced, Lordship. And I am behind the bar for 74 days. 72 days, Lordship. Medical report, mostly nothing will found. There's no incident happened, Lordship. Mostly brief of the history recorded there.
Yes.
My lord, yes, during medical, no evidence of sexual intercourse found and no injury.
When was it done? When was the medical done?
Medical was incident was occurred on, my lord, 14/6.
14/6.
14/6.
And medical was done on?
15.
16.
15.
Gang rape, it was the allegation of gang rape, Lordship.
Huh?
It was the allegation of gang rape.
Gang rape but as per 183 statement, my lord, she stated that rape by only one person, not by others.
Otherwise, I am behind the bar for 72 days, Lordship.
My lord, kindly peruse and birth certificate, as per birth certificate, she's her date of the age on that date, my lord, 14 years 10 months. 14 years 10 months. As per medical report also, my lord, between 12 to 14.
Ah.
History. Medical history is maybe misconduct, but 183 statement, madam, medical history.
History was recorded by the doctor, Lordship.
History was
The
recorded
first-
by the
very first incident. The doctor was the first man to contact with the victim,
that-
and she has told the true story. Brief history in the first page of the medical report, Lordship.
Medical report is only to check, my lord, whether
Huh?
regarding determination of age or my lord, regarding injury and all this, my lord. Regarding the incident.
This is medical history.
Brief history of the.
Oh, we are not believing this at all. So doctor who's signing it? Senior medical health officer? She went to SHOPE shop.
He was left at around 2 a.m. Subsequently, she has come. She become unconscious as per 183 statement.
This is only concocted story.
Yes.
But he's appearing for the informal matter.
There was a lab erection, but the fact is that on the extending, the accused person, the present accused person, petitioner, along with two other persons, forcefully taken the victim gun. And in the river side, Brahmaputra river side, there is a river embankment, and on that embankment, it has, beside the, there is a jute cultivation. In the jute cultivation, the present is committed.
Huh? They took her to the jute cultivation area.
Yes, yes. The present status is that what is the family member of the present petitioner and giving certain to settle the matter. Otherwise, we'll see.
The story of jute cultivation comes just a fresh loss.
No evidence of any sort in the medical record, nothing. And now, for the first time, I hear that there was a love affair.
We are ready to face the trial.
Huh?
We are ready to face the trial, cooperate the further.
What is your age?
He
19.
is,
I have
Ah,
an
he
age of
will-
19-year boy only, Lord.
How many were arrested?
One, two.
What
One
about
is
the other?
guard, Lord.
What about the other one?
I don't have idea, Lord. I am a 19-year-old boy, Lord.
Heard Mr. SK put the learned counsel paying for the petition. We are allowing the petition.
Yeah.
He will not remain in your locality. He will remain outside. That much we can provide.
We will obey by conditions, Lord.
He will not be seen in and around your locality. That much we can provide. He will not be in contact with the victim
Lord, sir.
or the family members. 19-year-old boy on allegations where there is where the victim states that I was scratched on my face. Nothing in the medical report. No scratch. On the second day, there was no scratch. The medical condition does not show any sort of sexual intercourse. The first statement made to the doctor is they had dragged me to that extent. We'll have to balance it. We will have to balance it. 19-year-old behind the bars. Heard Mr. SK Poddar, learned counsel appearing for the petitioner, also heard learned APP and Mr. A. Ahmed, learned counsel, appearing for the respondent number 2.
Along.
A. Alam, respondent number 2. Huh? Mr. Poddar, the learned counsel has submitted that as per the FIR,
Yes,
the
15, Lord.
allegation leveled on the present petitioner is that he, along with 2 others, had taken away the minor victim, had raped her and had left her in an unconscious state at the edge of the embankment near the market. Full stop. He has submitted that as per the medical report, there is no sign of any sexual activity. And further, the statement, and further, it is an admitted position that the petitioner herein and the alleged minor victim were having a love affair, but he has submitted that there was no physical interaction between them, full stop. The learned, therefore, he has prayed that the petitioner who has spent 72 days in detention may be granted the privilege of a bail during the remaining period of investigation, full stop. The learned APP has submitted that the allegations against the petitioner is grave, where he had been accompanied by 2 other persons to assist him in raping the victim, and therefore the petitioner the petitioner would not be entitled to the privilege of a bail at this stage, full stop. The learned counsel appearing for for the respondent number 2 has submitted that the family members of the petitioner herein are threatening the informant to settle the matter out of court, and therefore the privilege of bail may not be granted to the petitioner at this stage, full stop. I have considered the materials placed on materials available, and I have also seen the case diary which has been produced by the learned APP, full stop. Having regard to the absence of any medical evidence, the statement made before the doctor who had recorded the first history, the age of the present petitioner, which is about 19 years of age, and I am of the considered opinion that the custodial interrogation of the petitioner for the present may not be necessary in the event strict conditions are imposed for him not to interfere or interact in any manner with the family of the with the informant or the family members of the informant, including the alleged minor victim, full stop. In such circumstances, it is directed that the petitioner shall be released on bail on furnishing a bond of rupees 15,000 with 2 sureties of the like amount to the satisfaction of the
Special Judge Morigaon.
special judge within bracket POCSO Morigaon. Full stop. The learned special judge shall be at liberty to impose such other conditions as may be necessary to ensure that the petitioner does not in any manner interfere with the investigation of the case, full stop. It is further provided that the petitioner shall not reside in the vicinity of the locality of the minor victim, nor shall in any manner interact, coerce, or threaten either the minor victim or the family members of the minor victim in any manner whatsoever, full stop. The bail petition is accordingly disposed of. য'ত লিখিছো যে সেই 2 local sureties who have command and control over the petitioner.
26 and 26 to 28.
Yes.
My primary contention is that the prime accused person in this case has already been released on pre-arrest bail by this honorable court itself on 28th of August. And here I am.
On 28th of August.
Yes. Joynur Ali, the owner of the dhaba. And already.
We are looking at the future, ma'am. We are on 27th of August today.
25th of August.
25th.
Mr. Sharma is coming.
After some time?
Just on legs, man. Where is coming?
Lordship, 133 has been shown to have been mentioned, Lordship, but I was the petitioner in the bail petition.
It was mentioned.
That is 1.5 kg of ganja case, Lordship.
33 was mentioned.
No, it was shown to have been mentioned by somebody, Lordship.
Not
Adjourned
shown
on
to have mentioned. It was
29.
mentioned in my presence, sir.
I have not mentioned, Lordship.
You have not, but it was mentioned by someone
So
33.
someone wrongly might have been, Lordship. It is 39, I am the petitioner, Lordship. It is the 1.5 kg of ganja, Lordship.
Yes, the CD is available, sir.
Okay.
33.
33.
Okay.
I am behind the bar for 41 days, Lordship.
CD not available.
1.5 kg of ganja, Lordship.
CD not
No,
available.
CD is not available, Lordship, but 1.5 kg.
We'll have it after lunch. We'll
Lordship.
bring it back after lunch. 33 recall koi diyo. Recall koi diyo. We are recalling. Whatever, we'll hear him. 33 to hey koi diyo, huh? Recall koi diyo.
Lordship.
Well, here Sarsit later on. Sarsit was called for, I think. This year was called for. Here, appreciation. No. Perhaps this year called for, but not received.
There are three matters.
Hearing in item number 30, my lord,
Ah,
we have been protected in the interim, my lord.
I am for 31, my lord. I have also been granted interim bail.
In all these cases, interim are there.
none of the cases CD has come.
This year called for, my lord. Not received.
29, 30. PCR has not come. We'll have to extend the interim.
That's right.
We'll have to extend the interim.
Interim.
Or your lordship may make the interim order absolute, my lord, and will appear before the trial court, my lord, as and when the summons are received.
A charge sheet has been submitted.
Yes, my lord. It has been recorded in the earlier order.
Then why the during your interim protection, the charge sheet has been submitted?
Yes.
Yes, sir.
During interim process, Sarsit has been submitted.
We'll
So
make
that
it
is why-
absolute. They'll appear as and when they receive summons to pay for regular bail. If the charge sheet has been submitted, would you require them in custody now?
That is
Only after the summons are received,
nothing,
they will be required to appear. Yes.
because interim was granted by
Okay.
when by without the knowledge that Sarsit has been submitted now, in the first instance.
Mm-hmm.
Interim is granted on the first instance, when without the knowledge that Sarsit is submitted.
So even at that
Yes.
stage, the court felt that the custodial interrogation may not be necessary.
May not be necessary.
Huh?
No, but it's for appearance, may not be. The custodial interrogation, in my humble submission, is not the only, my lord, subject to correction, my lord. Not only criteria, my lord. Other things, my lord, that is why perhaps interim was granted, my lord. Thus, may call, TCR has been called
No,
for,
why
my
TCR, my lord? It's in the domain of the trial court, and we
Sir,
have been granted
on the-
interim order.
On
We are-
their prayer, my lord, TCR is called for, my lord.
I didn't
No,
make
what-
the prayer.
Because I
No,
know-
Mr. Goswami, let us have it like this. He is, what do we do now? We call for the TCI and keep the interim bail extended.
whether it can be.
No, it can be extended. Once the charge sheet has been submitted, you cannot investigate any further.
Cannot investigate.
The moment they try to hamper or tamper with the prosecution,
Yes.
some complaint will have to come.
Yes.
The AB has to be recalled.
That is one.
That is one. They will receive a summon. The trial court will see whether it is necessary for them to be taken into custody for the trial or not.
Yes.
It is at that stage.
That is the prerogative.
Right. Now, in between the time when you're given this charge sheet and they are on bail
Yes.
and they are yet to receive summon,
Yes.
what happens?
And my third submission will be, my lord, this, without going to that, my lord, whether your lordships, considering the materials in the TCI, my lord, whether your lordship will be pleased enough to, my lord, grant the privilege of interim to the. that
Suppose
CA
we
was going by the-
suppose we say the anticipatory bail is rejected. Their prayer for anticipatory bail is rejected based on the materials on the charge sheet.
Yes.
Who will arrest them for what?
Arrest part, my lord, is not, my lord, my humble submission is a question here, my lord, because now, my lord, subject, if your lordship is satisfied that they are, lordship may think it otherwise. Also,
No, we are taking, we'll
But-
try to understand.
Yes,
you,
yes, my
definitely.
lordship may think that yes, they are entitled for anticipatory bail, my lord, going by the materials, my lord. And your lordship will make it absolute, my lord. But if your lordship feels after going to the.
We recall it. The interim protection granted to them is recalled.
Recalled.
Then what happens?
Then, my lord, they will have to appear before the trial court, my lord.
Ah.
Then trial court will see whether on the basis of the materials.
That will be when they receive the summons.
Receive the summons.
Yes. So what we had proposed to do was,
Plus,
whatever is the anticipatory protection given now,
yes,
we say that the charge sheet has been submitted,
Yes.
no apprehension of any arrest that remains
Okay.
till the time they
That
They,
lordship
they,
can-
they get the summons and appear and pray for a regular bail before the trial.
that can-
Will that be difficult?
Nothing but that.
And the person whom you had arrested, he was given an interim, he was released on the interim. He remains like that till he receives the summon.
Lord.
Yes. So who's appearing in 29?
My lord.
Mr. So-and-so?
I'm on regular bail, Your Lord. I will face the trial, Your Lord.
You are on regular bail. You are on interim bail.
Interim bail, Your Lord.
Huh?
Arrested.
Had Mr. A. Rahman, learned counsel, appearing for the petitioner in BA number 2052 of 2026. Mr. N.J. Dotto, learned counsel, appears in AB number 1543 of 2026 and AB number 1581 of Mr. S.S. Ahmed appears in AB number 1581 of 2026. Full stop. Mr. M.P. Goswami, learned APP, is present for the state of Assam. Full stop. It has been submitted that the charge sheet has been, that the investigation has culminated in charge sheet number.
Sheet number 231/26,
Hmm.
2726.
This, the fact of the charge sheet being submitted has also been recorded in the order dated 29/7/2026,
Sir.
passed in BA number 2052 of 2026, by which order the petitioner in the said bail application had been granted an interim bail. Full stop. Since the charge sheet has been submitted in the matter, there cannot be any apprehension on the part of the petitioners for further arrest for the requirements of investigation. Full stop. Accordingly, the interim protection granted to the petitioners remain extended till the time they receive summons from the learned trial court to face the trial proceedings. Full stop. On receipt of the summons, the petitioners would be at liberty to move appropriate application for praying for regular bail during the trial proceedings. Full stop. Accordingly, the bail petitions are closed.
Lordship will mention the trial court, my lord.
Huh?
Yes, I'm aware.
Till you receive summons from the trial court,
My lord.
this will remain operative. The
Right.
moment you receive a summon, you go and appear for
Right.
regular bail.
Right.
Ah. Three disposed. Huh? So, item number 32. Okay. Yes, sir.
May I please, Lord?
Ah.
That the charge sheeted case, my lord.
Hmm.
Petitioner behind the bar today 130 days, my lord. FIR at page number, my lord, 11.
Page 11.
11. So it has been.
Oh, yes. Inside the tin box, boxing and all, na?
Lord.
Ah. Yes, sir. Statement of the victim, what does it say?
Statement perhaps in the my lord, petition itself. my lord.
Yes, that
No,
is why we are asking you.
Yes, this 26. Paragraph, point number, clause 3, my lord, clause 3. Point number 3.
Nothing more to say. Yes, madam. We intend to keep him behind bars on your submissions. Yes, tell us.
Your Lordship, there is another material witness who needs to be examined, Your Lordship. If Your Lordship comes to page 29, Your Lordship, this is the testimony of the informants. Your Lordship got it, page 29, paragraph 4. Accused Sanjibul caught the breast of X. My husband caught hold of accused and brought him home and tied him up and called the police. Now, Your Lordship, her husband is, if Your Lordship will turn to page 28, her husband is, it's written, wife of Momrej Ali. And at page 22 of the charge sheet, Your Lordship will find that he's one of the listed witnesses. So, Your Lordship, this material witness may be examined first, Your Lordship.
Very well. Now, what do we do with the statement of the victim?
Victim.
Your Lordship, because she has also said, though her entire narrative was a bit different, but she has also said that, paragraph 3, Your Lordship, page 26. She said, on the day of incident, during morning time, I and accused were talking on the roadside. My maternal uncle saw us talking. Then my uncle and called the accused to our house and tied him up and called the police. Yes. So here one thing is consistent.
Paragraph
Yes.
11.
Yes, Your Lordship, but then I'm talking about the material witness, Your Lordship.
Where do we find in the charge sheet his name?
His name, Your Lordship, page
Mombridge.
22.
Okay, he's 55 years.
Yes, Your Lordship.
And what is this petitioner aged about? No, he will not be able to influence. 19-year-old fellow, how will he influence the 55-year-old?
No, Your Lordship, it's not that. Any untoward incident also may happen, Your Lordship. So which is I also, and from the charge sheet, I found that they are neighbors, Your Lordship, not charge sheet, Your Lordship.
We'll ask him not to reside in the particular locality.
I would still insist, Your Lordship, that this material witness be, this testimony may be recorded, Your Lordship, and thereafter the bail may be considered.
When is the next date fixed? When is the next date fixed, sir?
Plus over, my lord.
Any idea when the next date is fixed? No.
No, my lord.
Find out. Find out, tell us. Huh? After some time. If it is too long, it will see after some time. It was like item 32. TCR ekelege something case only.
I am for item 35. Here, I has sent a communication, my lord. He is unable to produce the case diary today, my lord. He
Why?
one accommodation, once, my lord. My lord, already 29 days.
Till now, 21 days.
My lord, only. Some recovery has made, my lord, which is not relevant to the case, my lord. Case number 28, my lord.
Oh, your name is?
In fact, my lord, during our arrest, my lord, incident of theft, my lord.
Can we find out if there was another matter of this?
Yes, item 30.
That is what
item
I'm saying.
34. Two petitions, sir, my lord. 34 and for 35. my lord.
35, 34. No, this 34. Have we granted any interim? No.
34 is appearing.
But the conducting counsel has informed me she is coming. She has went to lower.
No, they are asking for an accommodation.
Yes.
The CD is not here today. We'll fix it on the 3rd.
My lord.
On the 3rd? At the request of the learned APP, who has written instructions from the learned, from the investigating officer to pray for accommodation, list this matter again on the 3rd of September 2026.
Right, obliged.
May I please your
Huh?
May I please your lordship, let the matter fix at 2 p.m. My senior will.
You?
Yes, lordship.
83 at 2 lagi.
Deeply obliged, lordship. Matter may be taken up after some time, madam. Yes.
May it please your lordship. On the last occasion, your lordship has directed that the scan copy, the few pages have not been there. We had, your lordship's order is there, lordship can go through it.
The updated scan copy, has it come? The auction? 2 persons were arrested. And the section 48 notice was served on the
48%
sister of the co-accused.
both, who was basically omnipresent everywhere.
She is there everywhere. Ground of, in the memo of arrest, ground of
She
arrest.
even received the phone call
Oh, yes.
with that registry note and all has.
Entire TCR has not been received. When were you arrested? Thirty-one 10/2025.
31/10/20.
Nearly a year.
Stage of evidence, man. In the stage of evidence.
No, we wanted to see whether the
Yes.
arrest was correct or not. You have been giving all the notices to sister of the co-accused.
No.
Does it suffice?
Yes. In that case also.
If you have got 25 persons involved,
No.
one sister available,
Yeah, one
you
sister.
serve notice for all of them on that sister, it will suffice on the next occasion.
No. Let the entire TCR come, we'll inspect.
Third,
It was not there at that time.
we'll have it on the third.
Lordship.
We'll have it on the third, sir.
And,
Since you've already.
finally on the 7th, my lord, otherwise may not come also, my lord.
What time is it?
Because there are holidays in between, my lord. May not. 7th.
List again on the 7th of September, awaiting the scan copy of the TCR full stop registry to issue a reminder. To the Learned Trial Court to send the full scan copy of the TCR, including the IO notes and case diary for perusal of this court. Full stop. Registry to also put up a note.
Mind.
Last time to me.
ঠিক আছে, obliged.
But it was fixed on 3/9, my lord, for further review.
P9.
3/9.
We'll have it on 7th. Her ground is also served. 3/9. One witness left.
On the
And if it
statement.
is not there on 3/9, on 7/9, we'll take up the matter for.
As per the statement, my lord, both are.
That is
stating
all right,
different,
but the objection of the learned amicus, that one witness remains,
Lordship.
let that be examined. 3/9 will not change the world.
But last two occasion, nobody
It has
appeared
been
before the-
submitted by Miss M.K. Brown, learned amicus, that the matter is, that the only one witness remains, one material witness remains to be examined. Full stop. She has prayed that the consideration of bail may be made after examination of the said witness. Full stop. The learned counsel for the petitioner has submitted that the matter is again listed on 3rd of September for evidence. Full stop. Accordingly, list the matter on 7th of September 2026. On which the learned counsel for the petitioner shall apprise the court whether the material witness has been examined. Full stop. It has already been recorded by this court that the learned counsel for the petitioner has submitted that the statement of the victim itself does not indicate any offense under the POCSO Act to have been committed.
Oh, Lordship.
List again on 7th of September.
P6, 36.
Yes, so CD received.
CD not received.
Kindly have the instruction whether they have appeared.
Sir.
We'll take it up after the recess. Just that information whether they have appeared or not. After recess. At 2. 2 mane kya? After recess. See you later.
7:55.
Lordship, here I am
7:55.
appearing in 6 item, my lord. 41, 46, 47, 50, 51, and 52. And
You'll have to
others-
give it on a piece of paper, sir.
My lord.
Before that, my lord, earlier the CD was there, my lord, because of the fact that it took time, my lord, the CD was again sent back for updation, my lord. So today CD are not available to us, CD record.
All we are in
And-
interim. All
Yeah.
we are in interim.
Everybody is on interim.
And appeared before I.
All have appeared.
Yes, ma'am.
What is the allegation?
There is also maintainability issue, that is also,
Huh?
there is also a maintainability issue, my lord.
Maintainability issue regarding?
Regarding the, my lord, AB maintainable, my lord.
Why is it not maintainable?
It is, my lord, under UAPA 43D,
I'm submitting, my lord.
that part is also there, my lord. So we'll go on that also, my lord.
First, we filed the anticipatory bail. At that time, my lord, only BNSS was there. When we get interim and appeared before IO, they added the unlawful activities. So thereafter, they sent 35-3 notice. Again, we appeared before IO. Our second time, our statement recorded. While it was that unlawful activities added, my lord. Now, I do not know whether today they have not sent a diary, my lord.
That FIR is at which page?
30,
I have the file of 37.
37, 37, right?
Huh?
Page 9.
Page 9.
This FIR has been lodged by Uriam Ghat Ansolik Sutia Satto.
Huh.
That is also another issue, my lord. They registered 3 cases on same subject, my lord. One FIR lodged by Sutia Satrahantra, another by Forest Department, another by Social Forestry on the same subject, my lord. That's why, my lord, 3 cases registered. Now you come.
This relates to that entire washaway we had recently.
My lord.
Vokialty estate.
No. This is Golaghat, my lord.
This is what?
Mining.
This is where?
This is Golaghat, Uriam Ghat.
Golaghat district, yes.
Golaghat district.
This washaway was a result of this.
Maybe, my lord.
In a particular village, which is
Well,
called Kalwadi village.
The first FIR was lodged by Uriam Ghat Ansolik Sutia Satto, my lord. They implicated, my lord, even police and, my lord, Forest Department.
Naturally.
Then my lord, later on, my lord, the forestry and, my lord, social forestry has lodged an FIR.
That allegation is that at the behest of Forest Department and police, my lord, going on this, about 60,000 trucks boulder going by this way with the behest of police and Forest Department. That is the allegation.
And you all have permits for this.
My lord,
Mining permits or everybody has.
I have mining permit in Nagaland, my lord. My client, my lord.
And my name is not even in the FIR. Nothing, no allegation, nothing. I think best thing is my lordship may come for that.
The APP has prayed for accommodation to produce the updated CD list again on
On 14, my
14th of September 2026. The interim orders passed earlier shall continue.
Continue.
Developers.
all right.
6.
Is 6. Huh?
Lordship, Mr. A.C. Vishwas is appearing on behalf of the respondent number 2. I'm praying for the time being. He's moving before another court.
56. 56, my lord, search sheet submitted.
I'm praying for the timing, Lordship.
Just have instructions if the charge sheet has been submitted. Do we keep this pending?
They dispose of the other.
The respondent number 2 has appeared. We cannot do it without his presence.
Yes, ma'am. He is
Who appears for the petitioner? None.
petition number 56.
Yes. 84. 56 officer, 84.
I am so doing.
I'm sorry, that's your.
Yes, tell us.
84.
Here in the. 84, my lord, let my lord Mr. Sharma come, my lord, because he again went here, my lord. He just pending question. After one day, can be taken up after some time. my lord.
That wrong address, land sold off
Yes.
that part,
Now
ground is that he was not produced within 24 hours.
24 hours. Let Mr. Sharma come.
Okay, my lord.
May I please your lordship? Lordship, a matter kindly pass over for the time being.
What is the matter? Yes, medical legal report.
My lord, it's not here, my lord. My lord, this awaited, my lord.
Huh?
Awaited, my lord. Because as per my.
They are not under interim, sir.
Yes.
If you cannot
Yes,
find the
my-
medical report from the hospital where he was examined on the first day itself,
He was
what?
taking treatment in my lord downtown hospital.
So is it very far from acha, downtown report will go back to Sri Bhubi and then will come to this court?
Okay.
Is that how they propose to do it?
And,
He will come from Sri Bhumi,
they have to.
take treatment here,
They have to come, my lord.
take the certificate from here, go back to Sri Bhumi,
They have to come.
attach it with the,
Yes.
and then send it to you here in Gauhati.
If they come, my lord, another aspect, my lord, perhaps, my lord, he has also come, my lord, was directed to file an affidavit, and my lord, he proposed to file an affidavit, my lord. He could not.
Hopefully he has.
No, my lord, we could not get the sentence of waiting, my lord, but maybe informant is unable, my lord, because she was attending, she's continuously attending, my lord, the victim, my lord.
Mati diokson.
Victim is very well.
Mati diokson, mo uthibo lage.
As per the statement, my lord, deponent could not leave the victim, my lord, who is under her care, my lord. So could not.
Deponent is here in downtown.
No, my lord, they are in now.
Treatment complete.
Not complete, my lord, because of the.
Some treatment made on the
Some
first date.
yes.
You must have the documents. Medical documents you have. Please show it to him. We are seeing it today. We'll come back in 2 minutes.
No.
We'll see the document. Please see the documents.
Yes.
This will not be false, hopefully.
No, my lord, take treatment in downtown, then again they have shifted to some other hospital, my lord. So their condition is as such, my lord.
This dispute is, my lord, between
May not be a case of, my lord, subject to what my lordship will see, my lord. The lordship will see just in the
this dispute is
another
between the
aspect I
family
will
members,
point out, my lord.
between the two brothers, my lord, regarding
Very
the,
well.
my
My
humble
lord, sir,
submission, my
kindly-
lord.
So, out my lord, the grievous people, my lord. And they are the aggressor, my lord. The report also will find, my lord.
Hmm.
My lord, kindly see the FIR, my lord.
Hmm.
The FIR itself whispers that this is the family dispute because,
That-
my lord, before that, my husband often assaulted my son,
That
for
part, my-
which he sustained severe injury. The case relating to the said incident is pending before the court of law. So, my lord, the informant is also saying that her son, that is the son, attacked the father. This has been, my lord, mentioned in the FIR itself. So who specifically beaten somebody, this is not, my lord, accrued from the FIR itself. It is a, my lord, it's a clash between the two brothers and the nephews and something regarding the homestead boundary, my lord, in respect to the plucking of a jackfruit. So my humble submission, my lord, it is, in my perspective, my lord, what is the necessity of a custodial interrogation, my lord? I will appear before the trial, before the investigation, my lord. Our statement may be recorded. Then, my lord, matter will go in this way, my lord, and the fruitful result will come out between the brothers, my lord.
As a, my lord, I have to reply to what he is saying, my lord, because this is required, my lord. He is always, my lord, he is saying, my lord, that he was assaulted. There is it's a dispute between the, my lord, son and the father, my lord. My lord, FIR is, my lord, very, my lord, wrongfully, my lord, translated, my lord. Lordship will,
No,
Lordship may
my-
kindly see, my lord. That should not be,
No, my-
my lord, and he is taking that ground, my lord.
No,
The
Let us
Lordship see, my
let
lord,
us see, my lord.
what
বিনীত নিবেদন এই যে ইমান তারিখে
before
সকাল
Lordship-
অনুমান
what
10
were in the middle, down portion, my lord.
হুম
I will take the help of my informant, my lord.
Yes,
please read it.
May I read, madam?
yes, ma'am.
এর আগতে আমার
আমার স্বামী আমার মামার ছেলেকে মারধর করে।
হ্যাঁ, আমার স্বামী
আমার স্বামী এর আগেও আমার স্বামী আমার ছেলেকে মারধর করে গুরুতরভাবে জখম প্রাপ্ত করেছিল। এর আগে আমার স্বামী
he's reading it.
May I read, madam? এর আগেও আমার স্বামী আর আমার ছেলেকে মারধর করি গুরুতরভাবে জখমপ্রাপ্ত করেছিল আর উক্ত মোকদ্দমা এখন পর্যন্ত মহামান্য আদালতে বিচারাধীন হয়েছে। Before that, there was also, my lord, they assaulted these petitioner.
Father and son.
Yes, my lord, and my lord, I have inquired. The case is, my lord, what case is pending against the father of the present petitioner number 1.
Huh.
And at that point of time, he was a child in conflict, my lord. So against him, proceeding is, my lord, there in the juvenile justice board. That
Now he comes back and again again
Yes,
assaults. Yes, take down.
my lord
Third Mr. HR
প্রায় আমার ছেলেকে my lord প্রায় আমার ছেলেকে মারধর করে গুরুতরভাবে জখম প্রাপ্ত করেছিল আর উক্ত মোকদ্দমা এখন পর্যন্ত মহামান্য আদালতে বিচারাধীন হয়েছে। প্রায় আমার ছেলেকে my lord কয় রফলা
Okay.
Aye.
কয় রফলা তায়া খায় my lord
Yes.
প্রায় আমার ছেলেকে অফেন my lord
Of-
প্রায় আমার ছেলেকে I have instructed from my client this is a
So the wife says that my husband used to beat up my son,
son, my lord,
and
because-
therefore there is a case
because
between my
long-lasting dispute between them my lord.
This is
and
not
therefore a case is going on between my husband and my son. This is your interpretation of this
They are
fact.
saying that in that way, because
Okay.
my client also said there is a dispute between the long pending dispute. My humble submission, my lord, I will appear before the my lord investigating authority, my lord. Our statement may be recorded.
Okay.
Not try. What?
Okay.
Right.
Heard Mr. HR Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. MP Goswami, learned counsel, learned APP for the state. Mr.
M.A. Chaudhary.
Learned counsel appears for the informant and assists the learned APP. Full stop. The learned counsel for the petitioner had submitted that as per the FIR, the husband of the petitioner had assaulted the son of the informant, and there was a pending case in that regard. He has submitted that this is a family dispute where the sons and nephews of the informant had been
Regarding the plucking of.
involved in a brawl and some injury had been caused. Full stop. He submits that given an opportunity, the accused would appear before the investigating officer, have their statement recorded to enable the investigation to proceed successfully. Learned APP has submitted that there is a wrong translation of the FIR, and in fact, the accused had earlier attacked the husband and the son of the informant, and there is a case pending between in that regard. Full stop. The learned counsel appearing for the informant has submitted that the said case number is
My lord, juvenile justice case number 2849/2021.
full stop. Which is the accused number here?
The petitioner number 1, my lord.
The petitioner number 1 is the accused therein. Full stop. The learned APP has submitted the medical documents made available by the learned counsel appearing for the informant, and this court has perused the same. Given the materials on record and the facts and circumstances of the case, where it is apparent that the petitioner number 1 has been again involved in a brawl with the husband and son of the informant, and has caused serious grievous injury during the pendency of another case against him, I am not of the opinion that the petitioners can be granted the privilege of a pre-arrest bail, full stop. Accordingly, the anticipated bail petition is rejected. You make a mistake for one, you make a mistake for everybody, sir.
Petition number 2, my lord, has no earlier any antecedent.
Very good. Go and say that when you are taken into custody. Why the wrong translation?
No, my lord, this is prior, my lord. What
Don't-
I have seen, it is a prior, my lord. Prior offense.
Yes, next. Disposed. Disposed no, dismissed लिखिए.
My lord, case succeeded. All for the Syncope lordship, the session tribal case lordship, in time was in nine.
Where is the FIR?
FIR page 8 lordship.
Regarding what? Sukha also require prane mara bhabu ki kore. The learned APP has submitted that the investigation is culminated in
That's it.
charge sheet number
Right number 183/26 dated 18/8/26.
stop run it.
183/26.
Learned counsel for the petitioner has called for calling of a scanned copy of the TCR. Accordingly, call for the scanned copy of the TCR. Miss has entered appearance for the informant and would assist, would assist the learned APP. He has to allow you to speak. We can't help it. Yes, next. List again on 18th of September.
Lordship, short date given lordship, the 10 lordship. AB, my lord. 10 lordship.
When?
AB, my lord.
When?
AB, 10.
Scan copy of the TCR, 12th.
10. Today, my lord.
12 September.
Yes.
Lord, can it be passed off for timing, my lord? Advocate,
CD was received 4 days ago.
Advocate Ayan Ibal will be appearing in this case. Sit with the lordship.
He wants a passover for the time being. Duta niki.
6.
May I please your lordship? My lord, I am on interim bail, my lord. Diary was also, my lord.
Succeed file, my lord, here.
Or within 7 years, it is there. This is within 7 years.
Yes, under POSO, my lord. Here, my lord, we were provided with interim relief, my lord. Because all the offenses were, my lord, where punishment is less than 7 years. And
No
for
notice.
that, my lord, no notice was given to us. Mainly on that ground only, my lord, that interim relief was provided and we appeared before the IOMA.
Yes,
Now,
sir.
Now, my lord, succeed laid down by number 60/26. Dated 5/6.
They'll appear before the trial court as and when they receive the
Come on.
summonses. The heard Mr. U. Chaudhary, learned counsel for the heard Mr. U. Chaudhary, learned counsel for the petitioner, also heard Mr. MP Goswami, learned APP. Mr. S.C. Biswas, learned counsel appears for the respondent number 2. The learned APP has submitted that the investigation has culminated in charge sheet number.
60/26 dated 5/6/26.
The petitioner had been granted an interim protection by this court by the order dated 14/7/2026 full stop. Since the charge sheet has been submitted, there can be no apprehension of the petitioner being arrested by the investigating authority.
no, my lord, as charge sheet has been submitted, my lord, there is every likelihood that, my lord, as it is a case of POXO, my lord. So if I appear before the, my lord, that court, my lord.
That the court will see, sir. That we will not grant it.
So only, my lord, considering the merits of the case, my lord, that the trial court should consider, my lord, our bail application.
There is no apprehension of the petitioner for arrest by the investigating authority at this stage. Full stop. Accordingly, anticipatory bail petition is closed. However, the petitioner shall be at liberty to approach before the learned trial court on receipt of summons, comma, in the event he has been put up for trial and pray for regular bail. What you have to do there, sir?
But this is a charge sheeted case, my lord.
Hmm.
Someone was issued. Someone issued, my lord. And
Someone issued.
yes, my lord. Subsequently, my lord, during the first hearing, my lord, before this court,
Hmm.
it is noticed that later, my lord, NBWA is issued, my lord. So,
Where?
my lord, here, my lord, this is not order. When I filed, my lord, that was not, I have apprised this court, apprised this issue before this honorable court, my lord. On hearing this issue, my lord, TCR was called for. Today, TCR is received, my lord.
Some NBW has been issued against you.
Issued.
Why?
Because, my lord, we did not appear, my lord.
After receipt of someone, you did not
Did not
appear.
appear.
Why?
Because, my lord, there is it's a non-bailable section, my lord.
So,
So there is an apprehension of, my lord, taking into custody. We have filed, my lord, anticipatory bail application before the learned additional session judgment, which was rejected, my lord. I have annexed page 18, my lord. Thereafter, by passing order dated 2/6/2026, thereafter, my lord, I approached before this honorable court for anticipatory bail. my lord.
so now we'll take up the functioning of the trial courts.
No, my lord, if
Now, he has to appear, my lord, or
we are, my lord, we will face trial, my lord, since protection is required, my lord. Otherwise,
Why?
my lord, if we appear, my lord, we will put into custody, my lord, because it's a non-bailable section and this is going on to taking into custody. So that, my lord, I approved before the learned session judge earlier, my lord. Page 18 and 19, my lord. Cage is basically, my lord, vendor.
Then in every case, where it is sessions triable, on the charge sheet being submitted, we can have one more bench that will be granting bail from here.
My lord,
Huh?
here in this case, my lord, order passed by the learned magistrate, my lord. Page 17, my lord. Learned additional session, CJM, my lord, passed this order, issuing summons, my lord.
rejection order is page 18.
Rejection, this is because of anticipatory bail under 482.
Will we sit here and give you
Order,
The articles thereafter, my lord,
order passed by the learned additional CJM, my lord. Page 17.
Chetan filed a sub.
Where is the order dated 792023? Sir, kindly go through the TCR to find out the order dated 792023, where their prayer for bail had already been rejected.
Well, 7923, my lord.
We'll have it at 2.
After some time, I'll see.
We'll have it after the recess. After recess.
Well,
After recess.
In this case, my lord, petitioner is in interim, my lord. He also appeared before the IO.
he did not receive, my lord. Mukalman. Mukalman.
He says he has appeared.
Yes, my lord. Against me only allegation that I participated in the gambling, my lord. Section 13 and 14 only attract against me, my lord. The remaining part, my lord, against the other accused, my lord. Only against me, my lord. Section 13 and 14 of Assam Game and Betting Act. my lord.
Oh, not only money, you are using
No, my lord, I am not, my lord.
e-stamps also.
Other accused, my lord. That is not my part, my lord. Other
You
accused-
remind us of the Mahabharata, where they were playing for land and family members and everything, huh?
No, my lord.
No, there are other remaining.
List
existing-
again on
14.
14th of September 2026, awaiting the case diary. Interim order passed earlier continues.
My lord, till then, my lord, interim. I am in interim. My lord.
এইটোত নাযায় নেকি মাত্ৰ? Till then interim order continues কৰাৰ পিছত যে interim pay কৰি আছে?
Obliged, my lord.
Yes. Item?
Okay, this FR is at page
Sila?
23.
Page 23.
I have seeking another date, my lord, CD not yet received.
Are you on interim, madam?
Okay,
In Hyundai i10, 2 cows stolen.
Hmm?
Hyundai i10, i20,
Hmm.
2 cow.
How do they fit them in? When? Case diary when? 7th?
9,
9th?
9.
At the request of the learned APP, list the matter again on 9th of September, awaiting the case diary. Full stop. The case diary had been originally called for by the order dated 11/8/2026. Full stop. The same may be brought to the notice of the investigating officer.
63.
No, no.
Huh? 62.
Some mistake?
62, 62 already, my lord, 61 and 62 Mukalma.
Same police.
14/9, 61, 62 is same, my lord.
Same, same FIR?
Same affair.
Oh, so 61 or 62 ekata date diok.
14.
61 or 62 ekata date hobo. 14th of September.
14. 63 also should not receive.
But where is the page number 14? 14, my lord.
14.
14, my lord. My allegation is that 2 kettles were recovered from
Hyundai i20.
one Hyundai i10.
We will be now surprised if you recover it from a scooty.
But he's the owner, my lord. So, well, if some protection is granted, he is ready to cooperate with the IO, my lord.
Let him go and produce the.
Owner will not bring in I20, my lord.
But
Huh?
he's the
Owner will not bring in I20.
he's the owner, my lord.
He is the owner of the car and owner of the
And
cow.
driver is different person, my lord. So some protection, my lord, he will appear.
Found 2 numbers.
On 9,
Since
9,
cattle already recovered, my lord.
Both ran away.
Yes. After seeing the police signal to stop the vehicle, smugglers managed to fled away. So just because the car was registered in the name of the present petitioner, perhaps, my lord, police is searching for him, my lord.
Who was using your car?
His driver, my lord. We have named the person, my lord. So if he is allowed to appear, my lord, he will.
And where do you belong to?
Alamganj, Pahartuli. Alamganj, Pahartuli.
Dhubri.
And this is Gauripur.
Gauripur place.
The police know the phone number of your driver. The police knows the cattle is being stolen, cattle is being taken away. And you, the owner of the vehicle, don't know anything.
But I give
How
the
innocent.
car to my driver, my lord.
When?
9.
9th of
Ninth.
September.
Highly okay.
Your car is being used to smuggle cattle. The
That is
police know
their
the
case,
phone
my lord.
number. The police know the number of cattle. The police know the car number, everything.
Yes.
Only you don't know that cattle is there in your car.
I came to know after the FIR was lost. That's why I went to APM. Highly okay.
Please, your lordship, notice not complete. It's a FOXO case, notice not completed.
Notice?
Upon the respondent number 2, the informants.
But notice regarding that, my lord,
I have checked the office record.
awaited, my lord.
We have already taken.
24/8. 24/8, huh? We'll have it on 7th. 7th of, list again on the 7th of September, allowing the learned APP to have the survey note, report of service of notice on the respondent number 2. Case diary has arrived.
Yes. it is.
Huh?
Yes.
What does it indicate? Oh, many days ago, someone had sprayed that one?
Yes, lordship. Some intoxicating substance was sprayed by the neighbors of the.
He was somewhere in the railway station.
My lord. 15 years, 183 statements.
Hmm?
183 statements are available.
No, just tell us. Series of incidents occurring between July 2024 and the last one happening 1.5 months ago. Repeatedly sprayed suspected anesthetic and intoxicating substance into the resident to render us unconscious.
That too by some unknown
So
perpetrators.
they keep on keep their windows open all the time. List again on 7 colony Ketu.
The lordship
Seven.
direct to retain the case diary.
Yes,
Diary will be retained, lord.
statement of 2 victims.
Ha.
2 victims.
Retain the case diary till 7th.
Lordship. Lordship, lord.
Anybody arrested till now? No.
Hmm.
In that case, nobody.
Please, your lordship. Lordship, it is a seated case, my lord.
Hmm.
87. 87. Sarsit, the petitioner before your lordship has been shown as a absconder in the Sarsit. But during the course of investigation, she has been never been charged by the police, my lord. And the sections of law, my lord, under which the Sarsit have been laid. Out of other sections, my lord, one section is exclusively triable by the Court of Session, my lord. That is 108, abatement of suicide, my lord.
CD not received. Oh,
CD no, yeah,
succeeded, no?
Sarsit.
Can be here.
So lordship will kindly come to
Can be
page
here also not.
15. That is the complaint, my lord. Lordship will kindly see my role in the entire case, my lord, for a moment, lordship.
What is your name?
Onita Paul, my lord. Onita Roy,
Anita
alias
Paul.
Onita Paul. Page 15, lordship will find the complaint. That is the type copy, my lord. It begins from page 16, my lord. May I read, lordship? That I am Srimati Rupa Raskwa Das, wife of Dudul Das, resident of Kosgaon, ward number so-and-so, Biswanath so-and-so, filing this complaint against the below noted accused persons who have illegally grabbed my deceased husband's land and subjected him to mental torture, ultimately drove him to commit suicide on 27/2/2025. That the below scheduled land in question was the lawful property of my deceased
Yes,
husband.
sir. Just a minute.
Lordship.
ভতিজা জুমনি আমাক বহিব দিছে গতিকে আমি আহিলে মাৰি পেলাম Mr. Parashar,
Hello.
The allegation is that they are sitting on that land and they had said that to ভতিজা বহিব দিছে আহিলে মাৰি পেলাম. Husband goes and commits suicide. Require custodial interrogation on that? Or is there a fear that they would again go and attack the wife?
It has already been laid, my lord. Only apprehension is that, my lord, if I appear before the committal court, because on the first day itself, NBW has been issued against me.
Have you given the charge sheet here?
Lordship, Sarsit, I have already annexed, my lord.
It's 20 to 34.
Sarsit also, nothing has been there, lordship.
But then the same question arises. If you don't go and appear, we'll be taking over the role of all the courts below.
No, my lord, my only respectful submission will be that, my lord, that I will have to appear before the committal court, my lord. And I have been shown as a absconder, and in the first day itself, my lord, without issuing any summon upon the accused,
We'll
my lord,
protect him till the charge sheet, till the charge sheet is sent
till
to the
appearance, my lord.
trial court. And once he appears before the trial court, he'll pay for his own bill. Heard Mr. So-and-so learned counsel appearing for the petitioner. You are Mr.
P does not.
P does.
P does.
Learned counsel appearing for the petitioner. Also heard Mr. K. Parashar, learned PP. This is an application for pre-arrest bail
Case 37 of the.
under section 482 in connection with
My lord, PRC case number
PRC case number
2025.
corresponding to Bishop. The learned counsel for the petitioner has submitted that
Yes.
during the investigation period, comma, the petitioner had not been called for to participate in the investigation. However, a charge sheet has now been submitted and the case being triable by the
Court of session, Court of session, my lord.
by the court of session, comma, the petitioner is apprehensive that on her appearance before the learned
Committal court, my lord.
committal court, comma, he may be taken into custody. The petitioner may be taken into custody. Full stop. I have seen the charge sheet. And I have seen the copy of the charge sheet which has been annexed to the petition. And I have also seen the allegations against the present petitioner. Full stop. Upon considering the same, I am of the opinion that the petitioner can be allowed the privilege of a pre-arrest bail till the stage when the case is committed to the trial court. Full stop. Accordingly, on the appearance of the petitioner before the committal court, comma, he shall be he or she shall be released. The petitioner, namely so and so, shall be released on bail, furnishing a bond of rupees 10,000 with one surety of the like amount. Full stop. Upon receiving summons from the learned trial court to
Lordship,
face
it-
trial.
Because, Lordship,
Upon receiving summons from the learned trial court to appear to face the trial, comma, the petitioner will be at liberty to pray for regular bail before the learned trial court, full stop, which shall be, which application will be considered on its own merits.
Subject to correction.
In
In case of NBW order, NBW is there, he should have come under 528. In case of BA, after NBW, then it can come in regular bail. In case of AB, that order will remain, in 482, cannot quash the order and issuing NBW. That order will remain.
NBW is there already.
Lordship, in the first day itself, NBW has been issued without issuing any summon.
528.
My case is that, my lord. In the first day itself, upon the.
If
report
there is
of
an
the police.
NBW, sir, without interfering with that order, can I grant you the pre-arrest bail?
Lordship, that order is on the face of the record. That order
Bad.
is-
Can I say so in an anticipatory bail petition?
Yes, in appropriate petition has to other.
We agree with you. It may be a very bad order. It may be. But can I set it aside in a petition filed under 482?
Lordship,
Can it be done? Strike out that order. Strike out that order. Heard learned counsel appearing for the, heard Mr.
P does not.
P does learned counsel appearing for the petitioner, comma.
Yeah.
The learned APP has brought to notice of this court that NBWs have been issued against the petitioner. Full stop. Accordingly, Mr. P does learned counsel for the petitioner prays for an accommodation to move appropriate application regarding appropriate application before this court, full stop. List the matter again on 7th of September,
7th of September.
allowing time to the learned counsel for the petitioner.
My lord, we will have to file a fresh application, my lord, under 580, 528, my lord.
That is, that this may be.
So those days are gone when I used to sit in the chamber and advise.
Lordship, not, then, my lord, I may be allowed to withdraw. Then I will file a fresh application, my lord, under the appropriate
Okay,
provision of law.
then strike out disorder also.
That will be
Take down,
appropriate, my
heard
lord.
Mr. P does learned counsel appearing for the
That will be
petitioner who prays for being allowed to withdraw the present
Lordship.
application and file an appropriate application. Full
Understood.
stop. Prayer is allowed, liberty as prayed for is granted.
Lordship. Obliged, lord.
May I please, your lordship?
Yes, sir.
Petitioner challenged a discharge order, my lord. My lord, a case was registered against the respondent number 2, my lord. The FIR is page 12, my lord. I am reading the FIR, my lord. Thereafter, my lord, the investigation completed and charge sheet also submitted. That is page 11 portion 21.
Then?
And after charge sheet, my lord, since offense was session tribal and it was registered as session tribal case, and the learned, my lord, additional session judge, page 24, my lord, discharged the accused person, my lord, very first day, my lord. In fact, my lord, so many ingredient of offense is present here, and section may be altered also. And without, my lord, considering ought to have framed charges instead of discharging the accused. And it is the, my lord, miscarriage of justice, my lord. So a person, my lord, married and some days stay with her, initially hotel, thereafter the sister's house of the husband, and thereafter he fled away. He said that I have not married you, and even threatened also her. And thereafter affair was registered and charge sheet also submitted. But the learned trial court, my lord, how discharge the person without examining the witnesses, my lord? Because it may be altered the charge also. Sometimes, my lord, the charge sheet is not submitted in appropriate section, but offense is disclosed, my lord, from the evidence and witness which was placed before the court, my lord. So my only humble submission, my lord, it may be remand, my lord, and carefully, my lord, take the action. And after
Under what? Give us the sections that this is under what the offense should lie.
my lord, I am reading, my
Do
lord,
not burden the session judge or do not burden us.
Yes,
Just tell
my
us these are the sections.
my lord, one section, my lord, that is 81 BNS.
81
81 BNS. is-
BNS.
Yes,
Okay,
my lord,
let
it is
us.
present here. The ingredient of the section,
What
my
is
lord,
81 BNS?
81 BNS, my lord, the charge sheet material clearly revealed that the accused deceitfully induced the petitioner to believe that she was lawfully married to him by performing a marriage ceremony in a temple and thereafter cohabited and established physical relation with her on that basis, thereby satisfying the ingredient of section 81 of BNS relating to cohabitation caused by deceitful belief of lawful marriage. That section is present here, madam. If we peruse the FIR and charge sheet, madam.
On the basis of the allegations.
Yes, madam. And next, another allegation, madam, here, section 83. Earlier it was 496 of IPC, page 7, my lord. Section wise, my lord, I have a statement given there. The my lord, here on record disclosure that the accused went through a marriage ceremony with the petitioner with dishonest and fraudulent intention.
He
And
threw a
subsequent
marriage ceremony.
ceremony in temple, my lord, some other person was present there.
Acha.
Because the petitioner and not the respondent number 2 only, some of his colleague and friend also will take part. And that is a kind of ceremony. And next, my lord, another section also present here, 318 subsection 2, my lord. Here the
You are saying section 81,
81, 83,
83.
318 subsection 2, and my lord, another section is 127 subsection 2 BNS. Earlier was 342, that is the confinement. Because she was kept some more days in the house of respondent's sister. She was not allowed, my lord, to go anywhere. And my lord, another section also, my lord, 351, and these are, my lord, offense may be altered, my lord, but in fact, he cannot discharge from this case, my lord. The learned judge, my lord, how has discharged very first day? That is very
Okay.
unfortunate.
Yes.
I have never denied the marriage.
Huh.
The marriage was solemnized in a temple in a public place.
in presence of my friends, 3 friends.
Hmm.
That has not been denied, and in fact, we lived as husband and wife as per the recital of the FIR itself, as husband and wife after our marriage. In fact, if your lordship peruse the 183 statement, all has been mentioned that we stayed as husband and wife. We have rented out a house.
Hmm.
Her relatives came to our place, and
So
we
you-
set up the rented premises. Thereafter, some matrimonial dispute arises between them. In fact, now the wife, the lady has filed a maintenance case under section now 144 BNS. So who files a who files a application under 144 seeking maintenance? A wife itself filed. And in fact, I have filed a divorce application. In fact, it's a dispute of matrimonial dispute. May I pray your lordship to produce the pink flag lots?
It's not a
183.
conjunction. No, the issue.
It's a matrimonial dispute. After the marriage, some dispute arose. And in fact, regarding criminal intimidation, I have not threatened it. Some other persons have threatened it. In
That is
fact,
what the FIR says. Someone said that your husband is
have
dead and we will
threatened
do
it. And
so.
section 69 is itself not applicable. In her 183 statement under 183, she has clarified everything. That my mother and my sister disputed the marriage. They are asking that you leave her. All these happened, and thereafter this
Yes,
FIR
sir.
has been lost.
But what happened? Very
On the- on
interesting,
the-
my
on
lord.
the- on the
When
face
we
of
have
the-
filed this, I
Just
have
a
challenged
minute.
the discharge order.
Just a
Supplementary
minute.
report.
Just a minute. We will record his submission that he is not denying
Yes,
a
my lord.
marriage
I have filed-
lawful according to him.
Yes, my lord. That will
Then-
help us.
I have filed the
That's
divorce
right.
application.
Then he
Because-
has filed divorce application.
It's
Because,
application.
So
Yeah.
what is where is the question of a false marriage?
My lord, when we have filed
He has
this
appeared-
petition,
The
just a
process.
minute. When we have filed this petition before the
Mhm.
honorable court, challenging the discharge order,
Ah,
they
then
got the
everything.
information,
Now-
immediately they have filed the divorce petition.
Now kindly
admitting
tell, now kindly tell us
Yes.
on the face of what he has already done.
Yes,
By
ma'am.
filing a divorce petition, by appearing in your maintenance case, everything done.
Yes, my lord.
Should we further pursue this criminal revision petition or give it the quietus, allowing you to proceed in accordance with law?
Yes, my lord.
What to do?
Just only record
Will-
my land's
Huh?
friend
He
submission.
has already got a divorce petition in the court.
Yes.
I have.
Okay.
He
I have
has it
already
in the court. It's a
Understood,
matter
my
of
lord.
record.
No, already I have benefited because after filing
Yes,
this,
yes.
I'm
Excuse-
challenging, my learned friend already admitted that it was marriage.
No, you have appeared in the divorce proceeding.
Just now I have got,
Very well
I
done.
have got the receipt.
This is the last order also.
Yes, ma'am.
We'll close this.
Yes, ma'am.
Huh?
Yes, ma'am.
We will say that from whatever has been now placed by the learned counsel for the respondent,
Yes, my lord.
and since there is no allegation that he had attempted, it is on his part, he
Yes.
admits a marriage.
Yes, ma'am.
Therefore, this criminal revision does not require any
Yes, my
further.
lord. That's right. Only our case is that.
Mr. Anuddin Learned Counsel appearing for the petitioner also heard. Mr. Chaudhary Learned Counsel appearing for the
Respondent number 2.
respondent number 2, Mr. MP Goswami, Learned APB, full stop. During the course of hearing of this criminal revision petition, the counsel for the respondent number 2 has submitted that the respondent number 2 has filed a divorce proceeding. Now has initiated a proceeding praying for dissolution of the marriage between the respondent number 2 and the petitioner number 1, full stop. Confronted thus, the learned counsel for the petitioner has admitted that they have entered appearance in the aforesaid proceedings, full stop. It is thus apparent before this court that the petitioner had not resorted to deceit by inducing the petitioner number 1 to believe a lawful marriage when there was none, full stop. In such circumstances, both the counsels have submitted that this criminal revision petition need not be pursued further and can be given a quietus, allowing both the parties to pursue such legal remedies regarding their matrimonial dispute as is permissible in law. Accordingly, the criminal revision petition is closed, granting liberty to the petitioners to pursue their legal remedies as available in law in with regard to their matrimonial disputes.
Yes.
Criminal revision petition
Ambulance.
closed.
Much obliged.
Dear.
The petitioner before lawsuit for quashing of the FIR and charge lawsuit. Case of the regarding the same.
Where is the FIR?
This lawsuit at page 27.
Page 27.
So the case of the petitioner is that petitioner is a retired police officer.
Okay.
He retired from service in the year 2023. While he is working as an inspector of public action, was entrusted a case. Accordingly, he arrested the accused person and sent him to jail. And he, at the time of the arrest, they collect some the voice samples regarding voice conversation between the accused and the informant of the vigilance and education case. And along with they collect the phenolphthalein powder, by which they at the time of the arrest. Allegation against the petitioner is that the voice sample has not been sent. Actually, voice sample has been sent to the CFSL Gauhati the first time, but it was returned back by the CFSL there due to non-availability of the equipment. But the FSL report of the phenolphthalein powder has been collected by the IO, and that is the case lawsuit.
So, what is the allegation against you?
Allegation against the present petitioner is that he has not sent the voice comparison to the CFSL Chandigarh.
But there are records to show that you have sent it.
The fact is that in Vigilance and Education Department, the SP is the OC. It should be sent by the SP, but that means the OC lawsuit. As per the.
If you do not give it to the OC?
No, he already communicated to the OC, SP, but it was not. So in this case, lawsuit, the office knows their lawsuit that whether he has communicated to the SP or not.
Are you on interim?
No, I am not in interim lawsuit.
The trial, the proceeding, the trial is continuing against you.
Only notice has been, someone has been issued to appear.
And you have not appeared.
I filed this petition after that the notice has been issued. I submitted that order before the trial court.
Which order?
The first notice order in this criminal petition.
And the trial court is not proceeding.
Trial court fixed the matter in the month of October. FIR is at page 27 also.
You are appearing for whom, sir?
I'm appearing for the respondent number 2 and 3.
Allegation
Respondent number 2 is the informant and the respondent number 3 is the inquiry officer. What has happened, my lord? He was supposed to send a sample to the CFSL Chandigarh, and he was well aware that the sample has to be sent to the CFSL Chandigarh after it's returned back from the CFSL Gauhati, because they don't have that instrumentals or the equipment. So he was supposed to send CFSL Chandigarh. Everything was notified to him. What he did, he submitted a progress report without sending the FSL report, so without sending it to the FSL, and submitted the charge sheet in the meantime. And the demand aspect, the incrementing conversation, which was there in the sample, it was not there before the trial court. And the demand aspect was never proved in the trial. So that is his case. And now he has approached the High Court without appearing there in the trial court. And the trial court's next date is fixed in the month of November. Now, there are another technical issue is there, a small technical issue which I'd like to highlight this. Now, he has approached this High Court at the stage where the appearance date was fixed. Now, obviously, no copies were supplied under section 207 of the CRPC. So accordingly, as on today, I'm totally inept to argue in this case unless and until those statements are before me. What statements the CID has filed? The 161 statements. This is the basic requirement of any.
No, you are only the informant. You would say that you have filed the correct
Yes,
FIR and you want a trial to take
Yes, so
place.
far as my.
Yes, Mr. PP, are you not supposed to oppose this? It is on your broad shoulders that we would like to put this matter on. Whether the FIR can be quashed is something you have to tell us. He is the informant. He has given a complaint to you, to the state, saying that, look, this man has done this. He wants a quashing of it. You have started the prosecution. You'd be the prosecuting side, is it not? So you defend it. On when? On 14th? No, 15th. Either 15th or 24th. Choose. 24th?
24th, I have a date, if your lordship may kindly allow on 15th or 16th, any day.
15 of September 2026.
This can the record of the SBPS is required.
A record of the?
SBPS case, special case of 30.7.
We'll call for the trial court records.
So trial court record
Scan
already
copy.
there. Trial court record
I applied
already
for the
there.
certificate, but that was not provided to me, lordship, to establish my defense.
What he is asking is for
Lordship,
the trial
the
court record
allegation is
of
that I have
as
not-
far as
I have not-
07 is concerned.
I have not-
07 concerned, already the trial court record is before the High Court.
No, lordship, the trial court.
Trial court records are here or the scan copy.
Yes,
No, lordship.
trial court is a scan copy record.
Scan copy is here.
The CITPS case there, but my allegation is that I have committed error in ACBPS case. That is required, lordship, because allegation is
That
that
you apply.
I applied, but that was not provided to me. I have
It was refused.
not refused, but not provided till that.
How do you make another application?
I make all the application before the special judge also, lordship.
Make an administrative complaint.
I filed in
Sir,
the.
make an administrative complaint. Someone will have to look into it. I would not sit here doing that.
I applied and the record not yet provided, lordship.
Lordship, he has approached the RTI authority.
Let's-
Because the office record is required, lordship, because allegation.
RTI authority is going to give you certified copies of case records.
For the ACB authority.
Approach to proper authority. List again on the 15th of September 2002. No, admit. Admit full stop. List again on the 15th of September for consideration. In the hearing column. You bring what you can. Oh,
Hello.
In what time I am to mention one item, my lord?
please.
What happened, my lord? It is a bail hearing matter. So it is to be listed today. But unfortunately, what happened, my lord, the private secretary of your lordship, it is wrongly typed as 27/9/2026
Oh.
instead of 27/8/2026.
We'll have it on 31st of August.
My lord, tomorrow, my lord. Because persons are in jail. Tomorrow.
I don't know.
See,
Tomorrow we
that's
already
a typographical mistake, man.
we have this long list tomorrow. This will come somewhere in the end.
My lord,
If I allow it for 31st, it will come up in the top.
my lord.
It will be easier for you to argue. On 31st?
20.
Give a date of 31st, I'll allow it.
My lord,
A mention memo, on a mention memo. Kindly give a mention memo. I'll allow it.
oblige your lordship.
And in the reason you kindly write down, date wrongly fixed.
My lord,
Then they will allow, otherwise not.
my lord.
There is a similar prayer, lordship, that on 25th, this matter was fixed on 28th, lordship. And in the e-court, it is there, lordship, the correct date is there. But only in the order, lordship, it is wrongly listed as
Okay.
28th.
The order that I have signed, that is correct,
Lordship.
not the e-court. Yes.
That is there. Lordship, may kindly take up tomorrow, lordship. I have,
Tomorrow we have requested him, he has agreed to. We'll have it on 31st.
I will be out of session, therefore I am praying tomorrow, lordship. He is in custody, lordship, tomorrow.
He is also in custody.
As last item also, lordship.
As last item, okay.
Oblige, lordship.
Item 20, Yes, madam?
Yeah, please, your lordship. Lordship, earlier I have submitted before your lordship that already the prime accused person has been allowed to go on pre-arrest bail by this honorable court itself on 25/8, and this is the order that I have. May I submit the order?
My lord, CD receipt.
And I'm
Maybe.
interim. I am on interim. bail,
Maybe. Okay. This photos of
Yes.
someone in the
lordship.
dhaba.
Some Hindu deities.
My lord.
You really need or yes, as Mr. Goswami was earlier saying, that is not the only consideration. For any other consideration, you need him behind bars. Heard,
My lord,
Miss Elbon.
medical report also received. What is-
The fight was there. The gods were there. The fight was there. Fight happened in front of the gods. Who are we to interfere? Heard Miss Elbonic, learned counsel appearing for the petitioner. Also heard Mr. Sharma, learned counsel appearing, learned APP. You are there in the matter, sir?
28. Item
28.
28.
28.
Mr. Give the names. There are three petitions, if I'm not wrong. Huh?
Mine one is BA, the other two
Others are
is
AB.
AB.
You are in both of them, sir?
No, only one in 28.
20.
27.
Huh.
He is in 27.
Miss Elbonik in BA number so and so. Mr. Dotto, NJ Dotto in AB number 1392 of 2026, and Mr. Your name, sir? SN Mohammed in AB number 1326 of 2026, full stop. The present petition has been filed seeking bail in connection with Rohingya PS case number 143 of 2026, full stop. The contents of the FIR reveal that a fight had ensued upon a request made to the informant.
Remove the
No, made by the informant to remove certain photographs of deities from the dhaba of one of the accused. Full stop. The allegations are that on making such a request, there was a brawl in which the informant was harmed and he lost, and some material of value had been forcibly taken away from him. Full stop. The learned counsel for the petition has submitted that one of the accused, one of the accused has been granted bail by this court
On
in
25th of August.
on 25th of August 2026 in
AB 1532/2026.
full stop. The learned APP has submitted that the case diary is received. He has assisted the court in perusing the same, and in my considered opinion, the custodial interrogation of the petitioners involved in these bail petitions are not required for the moment. Full stop. Accordingly, are you an interim?
We are all.
According the interim protection granted to the petitioners by orders of different date passed in individual petitions are hereby made absolute. Full stop. The bail granted shall be subject to the condition that the petitioners continue to participate in the investigation process as and when required to do so.
I'm obliged.
Yes. But you have to write down the names of all the petitioners, huh? AB number, so and so petitioner name, BA number, petitioner name. Okay. Item 33. Yes, sir.
Lordship, 1.55 kg ganja was recovered, Lordship. I am
Ah.
behind the bar for 41 days, Lordship.
Oh. Yes.
And my child was ailing 4 months old child, Lordship. I have
4 month old child.
4 months old. I have given the medical certificate as well as the birth certificate. 33. 33.
Mithun Nath.
Mithun Nath.
33 no. আপনার কোনটা হবে?
33. Mithun Nath.
CD not received, man.
I am behind the bar for last 41 days, Lordship.
41 days, 4 month old child
Child, Lordship.
Suffering.
He is ailing, Lordship.
and it is 1.5 kilos. What to do?
I will ready to cooperate, Lordship. And no criminal antecedent.
He has to agree in this kind of
Minor,
cases.
minor. Next minor, I prefer.
No, he doesn't have to agree. He must not vehemently oppose it. Then I can consider.
Only 41 days minor, let him remain for some days minor. Next week.
60 days of.
We'll have it on third.
Minor.
Third, sir.
Kindly consider ailing child. Lordship.
We also have to honor his opposition at times. When was he arrested?
Ailing child. I am only.
When was he arrested? 2 months, 1 month ago.
41 days.
Ah, he still had an ailing child when he was roaming about with the ganja.
Lordship.
3rd of September, awaiting the CD.
Minor. Yes, the divorce.
Sorvok PS 87.
36.
36.
87.
87 or 26. 36. 36 minor non-APS that the lordship asked me to to confirm whether after the interim.
Have they appeared or not?
I tried to contact Malad, but I could not get the phone call, Malad. So any day, Malad.
No, but we had allowed them to appear.
Yeah.
Neither the council appears nor the petitioners appear.
Yes.
We do not know whether they have appeared before
They
you.
will not.
So
So
This was on 21/1/2026.
Perhaps on other occasions also they are not present. Made a phone call, my lord, but is not responding. my lord.
List again on the 3rd of September 2026, allowing the learned APP to have the updated CD and the updated status as to whether the petitioners had actually appeared before the investigating officer pursuant to the orders passed by this court. Someone told us in the first half that Mr. Iqbal would appear. It is that case?
No,
The CD is received? We'll wait for some time. Hmm.
That one, my lord, on 13/7/2026, NBWA is issued, my lord.
Why?
Because, my lord, after rejection of the anticipatory bail
Hmm.
by the additional session judge, I have, the time has come to appear, my lord, but due to apprehension, we have not appeared, my lord. So, my lord, our prayer are rejected
From when did you not appear?
from initial stage.
From 21/6/2022. Unfortunately, we'll reject it.
And my lord, my humble submission.
Huh?
Now, my lord, I would like to withdraw this petition because we have filed this under 482, my lord. And now, my lord, the NBW is issued, my lord. by
Oh.
this time. So
Learned counsel for the petitioner, Mr. H.R. Chaudhary, submits that he's under instructions not to press this AB in the present form and to prefer a fresh petition to file a appropriate application, full stop. The AB is closed, allowing the liberty prayed for.
applies.
Seventy-seven, 82 and 93.
77, 82, 83. None appears list after something. Yes. Where is your counterpart?
it's coming.
Diok, ahile. Yeah. What should we take up first, sir?
Lordship, up to your lordship, lordship may take up the bail, then I have the case diary.
Yeah.
There everything has been revealed regarding my lord Subhajit Bhattacharya.
Hmm.
He is the prime accused. He has sought for my lord pre-arrest bail.
But then, thing is, if he has challenged the
Yeah, that part is
initiation of the FIR, first we have to see whether the FIR would stand. In the event it does not stand, nothing more remains. In the event it stands, then we'll consider the AB. Agote hitu diok, No.
Criminal petition number 115.
Subhrajit.
I think the same ground.
Same.
Same.
Subhrajit also has filed a petition.
Yes, yes.
Huh?
Passing.
So you want me to take Gupta or Subhrajit?
I argued in Gupta.
Yes,
that's
let
why
it be Gupta then.
because Gupta is behind the bar.
Diok, ikon diok. Thank you.
Yeah, my lord, main limb of argument of the other side was that my lord, we cannot initiate two proceedings my lord, on the same set of offense allegations. Sir, our lordship will have to take up the GST for a moment. my lord. Only one provision I will place, my lord.
Yes.
General provision.
Yes.
My lord, 131 section.
Confiscation of goods and conveyances.
Yes. or penalty not to interfere with other punishments. Without,
Huh?
Lordship will see 131.
Without,
132 is the punishment.
for certain offenses.
Without prejudice to the provisions contained in the Code of Criminal Procedure. No confiscation made or penalty imposed under the provision of this Act or the rules made thereunder shall prevent the infliction of any other punishment to which the person affected thereby is liable under the provision of this Act or under any law for the time being. There in the GST itself. Now, Lordship will see, my lord, section 26 of the General Clauses Act.
General clauses এখন দিয়ক। নাই নাই লাইব্ৰেৰীলৈ পঠিয়াইছিল লাইব্ৰেৰীতে ধৰিব পাৰি। Just a minute, we'll have to take it from here. Yes, which section?
26.
26.
Lordship is got it.
We are trying. 26. Successors. Provisions as to offences punishable under two or more
punishable
enactments.
under 2 or more enactments. Where an act or omission constitutes an offence under 2 or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be liable to be punished twice for the same offence. So, my lord, at this stage, my lord, that punishment part is not there, my lord. It's in the stage of investigation. So that will come later, my lord. In this regard, my lord, I would like to place one judgment, my lord.
No, the penalty part will come to later on. We accept your argument that
after
penalty will be only under one.
Submitted only there, you can see, my lord, whether, my lord, it is of the same offense.
No, we want to hear you on the particular first argument of the petitioners that there are two FIRs arising out of the same offense.
Right.
One is with you, the GST people.
Other is STF.
Other is as the with the STF.
Right.
Now, he might have done some act of defrauding from the GST.
Perfect.
He might have been in connection with some other people in doing it.
My lord.
So therefore, all other these connivance, conspiracy, everything will come in.
Perfect.
But all this has to be investigated under one
That is
investigation.
my lord.
One investigation, not two. So now if you find that no, in this connection, he had also done a fraud with some other company somewhere,
Perfect.
which is not part of this transaction, but there may be other transactions also.
Therefore,
Those
my lord,
things
that
will be different.
investigation civil.
That will be a different thing. You are investigating it. Once you find out that this is also something, and this is not something we can touch, please go ahead. Otherwise, it will go on the same line.
No.
It will be the
Yes,
same investigation.
Here I would like to, my lord, refer to this particular judgment of the High Court of Allahabad, Govind Enterprise versus State of UP. On this, the Honorable Allahabad High Court held that, my lord, it is permitted.
Two FIRs.
Yes. DST proceeding will be separate, my lord. FIR will be under police, it will be different.
But it is emanating from the same thing.
Same thing, but my lord, the provisions are different, my lord. So far as GST part, my lord, our penalty is different. So far as, my lord, court is concerned, my lord, BNS is concerned, my lord, there it will be well, like, it will be, my lord, like sitting, fraud and all will come in, my lord. Lordship will see the, my lord, case by under which it has been raised at the provisions, my lord. Those are totally different, my lord. That cannot be, my lord, it cannot be said that, my lord, we cannot proceed on that part.
What we are understanding is, if it is a case of cheating or fraud,
That's true.
he has cheated not only some other people around him, he has cheated the department also.
No, not other people, my lord. They, my lord, have some companies, my lord. They used to show that there is supply of materials, buying and selling, my lord. And all these companies are, my lord, owned by them only, within their, my lord, own circle.
Understood. So now that cheating has been done to the department.
Yes, ma'am.
That is being investigated into by the department.
We have, my
What
lord,
else will the other side do?
on the same, but my lord, the provision, the penalties will be different, my lord, in the BNS as well as.
Could be. Could be. You go for the stricter one. There is no problem. But can you have two FIRs and two investigations out of the same issue? That is what.
But that has been dealt with by this case, ma'am.
By the Allahabad court. But what about the rest of the judgments which says no?
No, my lord, in fact, my lord, the one, my lord, the Punjab and Haryana courts, my lord, of 2024. There, my lord, this particular order of my lord Allahabad High Court, it has been mentioned, but it has not been discussed how, my lord, it will not be covered. I will place it, why, my lord, that order was passed. Lord Civil, my lord, have a look at that part, my lord, which my learned friend relied upon. Punjab and Haryana part. There, my lord, what was their ground? Lord Civil, see, my lord, para 4, para 5.
Para 5, he argued that as per the FIR itself, the respondents had initiated steps for recovery of tax and penalty.
Recovery was already initiated, one, my lord. Then Lord Civil, see why they took this plea. He argued that as per the FIR itself, the respondent has initiated steps for recovery of tax and penalty as prescribed under CGST Act, and therefore the action of registration of FIR is bad in law, since the Act itself provides for a mechanism of penalty and appeal. Then Lord Civil, see, my lord, para 11 again, my lord. Para 11. Heard learned counsel for the parties and gone through the records, and admittedly, in the report under section 173 CRPC, that is the search sheet submitted by the police, the investigating agency has not been able to bring on record any evidence against the petitioner, and the only evidence which can be derived from the petitioner is from digital data, which is the stand taken by the respondent in their reply. My lord, what here has happened is, my lord, the petitioner was my lord, he was a chartered accountant. He was brought to book under the GST Act. So there, this was the view. And Lord, you will see para 13 again. It is not understandable as to how the respondent asserted that the idea of forming a fake firm has been conceptualized by the petitioner, more so when only because the co-accused made a confessional statement in the police custody, admitting the involvement of the petitioner cannot be the sole ground against the accused, lest such confessions are supported and corroborated by cogent evidence which may prima facie point towards involvement of the petitioner. Then, my lord, para 21. In fact, in para 9, Lord, if you see down below, the reference of the Allahabad court's case, my lord, it is there. Bovin Enterprise versus State of UP. Decided on so and so. It has been mentioned there in my lord, but my lord, how it will not be applicable, it has not been stated, my lord. Nowhere, my lord. Then, my lord, what was the ground, my lord, under which that this passing was given, my lord? CBC at page 21, my lord. Why finally that order came? A close reading of the above cited case laws would lead to only one conclusion, that the offense alleged against the petitioner was one punishable under the UTGST Act or CGST Act, which are the special statutes and are a complete code in itself, in view of the special mechanism contained in chapter so and so of the CGST Act, which clearly provides.
Where are
for
you reading?
21, my lord.
21. Huh.
Clearly provides for offences and penalties for prosecution of a person violating 122 and 132 of the Act. The petitioner cannot be prosecuted under the general provision of IPC, especially in view of the fact that in the FIR itself, it has not been stated that that resort has already been taken for recovery of the tax. Lordship will see especially, that is the word used, recovery of tax by assessing tax and imposing penalty, interest and penalty thereon. Since as per the mechanism under the GST legislations has been pressed into a continuation of the proceeding under the general penal provision of IPC and subject the petitioner to face trial thereunder would amount to double jeopardy under Article 20 clause 2 of the.
Oh, so here already a penalty was imposed and allowing the
Yes.
imposition of penalty under another act would lead to double jeopardy. Therefore, it was not allowed.
And my lord, search sheet was there. Everything was placed before the courts. The honorable court, after perusing everything, found that even, my lord, there is no material against the petitioner. Today we are at the stage, my lord, when the petitioner, one of the petitioner, that anticipatory bail was applied, he is absconding. I will place the case there. In that case, lordship will see how the investigation has proceeded.
But then in that particular case, his another argument was that you have not even assessed it.
My lord,
You have given you have not
Now-
assessed it completely.
in our particular.
Those 12
Yes,
crore
we
or
have not
something.
initiated any SOCOs or anything under section 73 or 74 of the GST Act
Mm.
to penalize the petitioner, my lord,
Huh.
under the interest and all, my lord, penalty and interest. That part is yet to be, my lord, initiated.
But the part where the fraud has been alleged of the 12 crore something rupees, that you have assessed.
That, my lord, lordship, assessment is not required. I am placing that, my lord. In fact, my lord, Radhika's case, para 61, he has not read that part, my lord.
Radhika is at page
Lordship will find it.
124, huh?
124,
Huh?
para 61, lordship will see. He referred to 58. I'm sorry, I'm placing. Yes. Para 61, lordship has got. However, relying upon the judgment in Make My Trip, it has been submitted on behalf of the petitioners that the power under subsection 5 to section 132 cannot be exercised unless the procedure under section 73 of the CGST Act is completed and an assessment order is passed, quantifying the tax evaded or erroneously refunded or input tax credit wrongly evaded. According to us, this contention should not be accepted as a general or
Broad
proposition. We would accept that normally the assessment proceedings would quantify the amount of tax evaded, etc., and go on to show whether there is any violation in terms of clause so and so of the section 132 of the CGST Act. And that clause 1 to subsection 1 is attractive. But there could be cases where even without a formal order of assessment, the department or revenue is certain that it is a case of offense under clauses A to D to subsection 1 of section 132 and the amount of tax evaded, etc., falls within clause 1 of subsection 1 of section 132 of the CGST Act with sufficient degree of certainty. In such cases, the commissioner may authorize arrest when he is able to ascertain and record reasons to believe. So, my lord, it has been provided that in some cases it is permissible. It's not that every case there will have to be assessment, then they will go for the procedure.
That is what was preliminary in our mind also.
Yes, in fact.
Otherwise, you go for the entire thing.
So that, my lord, the argument also goes. And regarding, my lord, that 132(6), my lord, regarding the consent of the commissioner prior to closing the FIR, that is there. That they fulfilled and thereafter the FIR was lost. That is also there. So what I would say is, my lord, Lordship will of course, my lord, hear this issue because, my lord, it will have a bearing in other cases too. At this stage, my lord, no, my lord, intent should be, my lord, passed by this honorable court, staying the, my lord, further proceeding, because I will place the case diary in the other case, in the anticipatory bail application. Lordship will see how it has been proceeded. Because, my lord, the superintendent of taxes, who is, my lord, investigating the issue.
There are two
they
case
don't get that expertise, my lord. That's why they say that
there are two case diaries then.
no, so far as our part is concerned, it may not be a case diary,
But you have something to rely upon.
and I peruse, my lord, the way, my lord, the police are investigating and our officers, there's a vast difference is there. That's why they said we can go to this action. Thereafter, you kindly investigate. Because, my lord, there are, my lord, funds, my lord, involving, my lord, from Kolkata. In fact, my lord, prime accused is from Kolkata. So those, my lord, coordinating with those police officers from Kolkata, my lord, arresting someone, collecting data, tapping their phones. These are something, my lord, which the police are otherwise expert. That's why, my lord, the STF has been entrusted with these particular cases. That any FIR will have to be there. There's a decision of the government. So at this stage, my lord, what I pray, my lord, that of course, my lord, Lordship will hear this at length, my lord, and we will file an affidavit, my lord, including what we have found in the investigation, in the, my lord, criminal petitions. But, my lord, they have every right to, my lord, file, my lord, proper bail application before the honorable court, which one of the petitioner has already done, and which is before the honorable court today. There I will face the case there. In fact, my lord, I have landmarked the particular, my lord, statements of the arrested accused. Lordship will kindly peruse it. I will providing the case diary, and thereafter, Lordship may consider, my lord, the bail application itself. And my humble submission, my lord, so far as the bail application is concerned, bail applicant, that is Subrojit Bhattacharjee, he is the prime accused, my lord. He is responsible. Everybody's statement goes against him. All who has been arrested. He is the main mastermind, my lord. He used to provide some, my lord, monthly amounts to others, my lord. For that, my lord, they used to have the GST account. They even don't know, my lord, what is input tax credit. He manages everything. All statements are there, my lord. So Lordship will have to peruse that. I have flag my sheet, my lord, so far as the bail part is concerned. And, my lord, so far as, my lord, petitioner in the criminal petition, he has not moved any bail application. He can always move, my lord. In fact, the coordinate bench, my lord, while considering
This Vivek Kumar Gupta, he does not have any bail petition pending.
Tomorrow it is listed.
then, my
before your
lord,
lordship.
case diary will be available.
Hey, you are coming up with one. Every day we are taking up only your cases. What is this?
My lord,
You could have made a mention yesterday that this matter is being taken up on this so and so
It
that
was
tomorrow all the
filed
other matters are there. Kindly have it before this court
True.
together.
Tomorrow it is listed. In fact, application was given to registry for listing, my lord. Because
court itself.
Mr.
My-
Goyal, we expect better of you.
that is there. One thing, my lord, what my learned friend has submitted, my lord, if your lordship will
We bulldozed through the first half in the morning. That something will happen in the afternoon.
happen, my lord.
Now you come up to say that no, we have another
regarding
petition
bail-
coming up tomorrow.
regarding-
So we'll consider it tomorrow.
Well, no, my lord, regarding stay of the proceeding, my lord.
Stay of the proceeding at this stage, no.
My lord,
That
if I
was-
satisfy your lordship, my lord, in the Punjab and Haryana, which my learned friend has read,
No one has dissatisfied us till date.
my lord, in the Punjab and Haryana judgment, which my learned friend has held, and the provision which has been shown, your lordship, it is in respect of confiscation. 131, your lordship.
Not only 131, section 26 has been discussed, my lord. Everything has been discussed, which is missing in this, my lord, Punjab and Haryana's case. In detail, it has been.
And Punjab and Haryana High Court has decided on the basis of the decision of Honorable Apex Court. my lord. If your lordship may kindly see first Punjab and Haryana, then I will compare para 18 and 19. And question was, friend Manoj, the question thus arises that whether the FIR can be allowed to sustain for the provisions of GST legislation have overriding effect over and above the provisions of under the Indian Penal
Then Mr. Gogoi, kindly again clarify us one thing. This 2019 judgment of the Allahabad High Court relates to Mines and Minerals
Yes.
Act. Para 18. again of the judgment of the Punjab and Haryana High Court. It refers to a judgment of the Supreme Court saying that two FIRs would not be maintainable regarding the same act which the Allahabad High Court has discussed. This Sushil Kumar Singla case, huh? Number 18. Question before the Apex Court was whether the provisions contained in section 21-22 and other sections of the Mines and Minerals so operate as bar against the prosecution of a person who has been charged with allegation under 379 IPC. Apex Court held that if an offense is mentioned in so-and-so is executed by the accused, then such offense can be tried only under such act by the procedure laid under that act. However, if an offense constitutes an offense under IPC, provisions of so-and-so will not
That's why I'm saying
stand
not
up.
possible to be provision under which the case is registered, my lord.
Mm.
At this stage, my lord, at this particular stage, that's why I'm saying, my lord. In fact, that's why the third seat was considered in this case, my lord, Punjab and Haryana case. There are sections, my lord, they have not relied upon some provision of the GST.
Ipso facto, FIR will not lie, who is not there.
Directly, it's not there.
If your lordship will say, see, my lord, section 6
Of?
GST Act. In fact, they have been barred, my lord, for doing two investigation. Section 6, your lordship kindly see.
They will not investigate, therefore they are not investigating it.
That's why, my lord, there is, my lord,
they are not investigating.
In Tito Anthony, Honorable Apex Court held that there cannot be, my lord, two proceeding. And, my lord, so far as GST Act is concerned, my lord.
This is something you have shown us. 2014. State of NCT versus Sanjay.
My lord. Thereafter, my lord, the Honorable Punjab and Haryana High Court.
Then how does, if TT Anthony is totally correct, or is TT Anthony in this case is to be accepted, then what happens to State of NCT versus Sanjay? Which says that yes, there can be two different proceedings.
Or if an act offense which constitute an offense under IPC, then the provision of act shall not
stop in the way. Now, the FIR which has been lodged under the IPC, invoking sections of the BNS or the IPC, whatever you say, the moment those are invoked.
But my lord, the allegation in the F2 FIR are same, your lord.
The facts which are leading, which are leading to the two FIRs, the basic facts are the same. At one point of time, two different investigations are required. One, whether there was a fraud before the man was carried away to be murdered, and two, whether when the man was murdered, will he be tried away separately. But both originate from the same thing. One man paid the other without there being any reason to pay.
But my lord,
then there will be two investigations, sir.
But under section 132, where my lord, if there is a fraud, then there is a provision under section 74.
To do what? Under 74 to do what?
Section 74 of the Act. Determination of tax not paid or
very well,
paid.
very well. It will be determined once everything is in their possession. Your one man is on the run. They do not have all the materials before them. Therefore, the Supreme Court says that it can still proceed in Radhika itself, that you do not need to determine it before you start it.
That's why I'm saying under section 132, my lord, a special provision has been given. In those cases, a sanction from the commissioner is required, my lord.
That is there.
Lord, in respect of FIR before STF, no, my lord. That can be done.
Yes, Mr. Gogoi, you said there is a sanction for FIR against in the STF, and he's saying there is no sanction.
How will he know, my lord, what is there in a record?
My lord, that's why I'm saying to proceed under section 132. Sanction is required. To arrest, my lord, reason to believe has to be there. To bypass all these provisions.
To arrest and to have grounds for reason to believe that you need to be arrested and all.
Yes.
That will be under the GST. Now they have gone ahead and have taken the consent. Correct me if I'm wrong, Mr. Gogoi. I don't want to go wrong on facts. They have also taken the consent of the commissioner to lodge the FIR,
Yes.
which was not required.
My lord, the basis of that FIR is, although we have initiated investigation,
Huh?
but we are not well equipped.
Huh?
So please you also investigate the matter on the
True.
same subject matter.
No. You
see-
you further investigate what we cannot investigate. Not what we are investigating. Don't investigate what we are investigating.
Shown my lord, section 72.
Again we'll read 72.
72.
Each time you come back,
They
we'll
can- they-
go to
they
that.
can take assistance.
They
of
will
in-
they will take the assistance. They are empowered to take the assistance
My
to
lord.
investigate what they are empowered to investigate. Can they investigate the fraud, the cheating, the other documents, the making of what do you say that the counterfeit documents being presented? Are they
Yes, my
equipped?
lord. Yes,
They are
my
not.
lord. Because my lord, for taking
They will see to what extent you have defrauded the State Department. They will not be able to find out who helped you in taking up that counterfeit certificate.
It is not like that, my lord. In GST, the allegation is, my lord, availment of, my lord, wrong input tax credit, your lord.
True.
And everything, my lord, if I avail wrongly, your lordship.
This is just an example we are giving about the counterfeit documents and all. There are some aspects which they will not be able to investigate.
If that is so, my lord, if the act has been, my lord, GST Act has been legislated for the purpose of, my lord, collection of revenue. Lord.
Yes.
And my lord, if somebody is, my lord, defrauding with the state or center, your lordship, then there is a specific provision to impose penalty and all, and as well as in 17 to prosecute that person, my lord. A special provision has been given.
Prosecute under what?
Under section 132.
132. What is the maximum punishment?
5 years.
Does it give a punishment for the fraud part or for the evasion part?
Yes, my lord.
For the evasion part,
evasion.
not for the fraud part.
Also, my lord.
Where?
Section 74, your lordship, kindly see first. I may not be able to, my lord, I think to appreciate, my lord, place in right way, your lordship. Here, your lordship, see determination of tax paid, so refunded.
It will be
into tax.
determination of the
Due to
tax
that
not
reason
paid.
of fraud.
Now the punishment for fraud, that would be the separate part.
My lord,
It has to be bifurcated. Your one offense is you committed a fraud. Your second offense is you evaded it. Evasion, this I can tackle.
fraud.
Okay.
Evasion by way, just my lord.
We understand.
My lord. And my lord, for that, my lord, there is a provision to impose penalty and interest also, my lord. As well as, my lord, under section 132, there is a provision for imprisonment. Maximum imprisonment is, my lord, 5 years, your lordship. That's why in the case of, my lord, that Madhya Pradesh and, my lord, that I have faced, my lord, Madhya Pradesh High Court, your lordship, may kindly see once again, my lord.
Madhya Pradesh, Allahabad. Madhya
Para
Pradesh.
8, my lord. Para 8, page 16.
8. Page 16.
16, 16. Upon perusal, my married, your lordship. Upon perusal of record, it is apparent that a petitioner had been summoned under section 70 as he has taken right so and so, and he had been given his statement with GST authorization. Thereafter, no action so and so was taken against the petitioner by GST authority. GST authorities conducted such and seizure operation while exercising power under section so and so. Thereafter, your lordship skip over. So it is start from upon perusal of inspection report dated so and so. Along with FI, it becomes quite apparent that there is no allegations against the petitioner for forming the bogus firm, and even if the allegations therein are taken on at their face value, the same constitute offense which are squarely covered by penal provision of section so and so. It is not disputed that no sanction before launching prosecution, that is registration of FIR, was taken from commissioner as required under section 132.
So the facts differ.
My lord.
The facts are differing. They've got the sanction.
My lord, so far as, my lord, so far
Please go ahead.
So far as registration of FIR, my lord, in my humble sanction is not there. But for so far as, my lord, launching prosecution under section 132, commissioner sanction is required. That they have done in another case. The case similar to that, first FIR, my lord.
Have you filed your written response to the petitions?
No, we'll file it, my lord. But
by what time?
Lordship will record my statement with my lord. For the FIR also, my lord, there is a approval of the commission.
See, we had kept it pending from 2-3 occasions, only to see whether we could go ahead with granting an interim protection to the petitioner on the submissions made. Not very convinced on that as of now. So if you file your objections and we'll take it up, how soon?
In a week, I can file it.
Because the investigation is proceeding on both.
Yes, yes.
Tomorrow, if you have to stop it, we are wasting state money, we are wasting everything, we are wasting time, everything. When?
My lord, in that case, also will take up, my lord, in the next week or week.
No,
after
next
that.
week we have got 3 working days
Only 3.
out of 5.
Day, my lord, the week later, my lord. Or any day, my lord, I will file it by Friday or Thursday.
Today is Thursday, tomorrow is Friday, you will not be able to.
No, in the coming week.
Coming week. But you have got time till 3rd then. 9th. We'll take it up on the 9th. We'll take it up on the 9th for consideration of the interim being paid for by him. Based on your documents, based on your objections. You want, we can give a detailed order justifying why we are not granting it today, or we can say after hearing, allowing him some time. Further hearing on the further hearing on the interim will be considered on the filing of their objections, which they assure to do on or before the 3rd of September. And the further hearing would take place, hearing would take place on the 8th of September for the interim. And
Till then, my lord, one petition is before your lordship. His interim, my lord, so far as his pre-arrest bail is there, my lord. That may proceed.
they have the CD ready. Should we consider it today?
Yes, sir, we can consider.
They have the CD ready.
Lord, my submission, if your lordship will go, in the base jurisdiction question, my lord.
Unless we decide this, unless we decide whether if we had decided that you deserve a stay on this, the second FIR had to be stayed. In that case, the anticipated bail would have been an automatic result. Since we are not staying this as of today, you want that pending till 8th, or you want to take it up us to take it up on the basis of the case diary?
Till 8.
My lord, interim has been refused, my lord, on the first day. Just come up for case diary, my lord. Final disposal.
Not refused, my
The
lord.
case diary is here. We can just take it up.
If you not refuse, if your lordship will see, my lord.
It was relegated.
Relegated.
Whatever be it, either which ways. It is not a case where your liberty is at stake because you are behind bars. I don't see any hurry in that. But if you want, we can take it up. We can go through the CD. We can...
8th, your lordship.
All of this can be considered on 8th.
And tomorrow.
And since the case diary will be here tomorrow, remind us on 8th.
But
the CD would be here.
He is behind the bar tomorrow, my lord.
What can we do? On the first day, we'll ask for the CD, which is fixed for the 8th.
CD is here, your lordship.
On the 8th.
On the 8th.
All together.
Tomorrow, my lord, CD.
All together. No, had you made a mention today morning, we would have taken it up. Your manner of having it listed tomorrow and trying to move an application before the registry, the urgency, if that was there on your part, it would have been mentioned today morning, or it would have been told to us yesterday when this matter was taken up, that one matter has somehow come up on Friday, sir, have it on Thursday. Have we not allowed it? We have allowed mentions at 2 to have the matter fixed at 4.
That is true.
When you did not have any urgency at that point of time, please do not place urgency now.
I'm saying that since CD is there tomorrow.
Nothing doing, sir.
I filed 2 affidavits. One from the GST authorities to show.
You would have the respondents would be at liberty to file their affidavits.
Informant as well as the investigating authority. Both
Whosoever be, whosoever, all the respondents would have their liberty. You can, anybody of you can file. All of you can file.
The informant is probably not a party. Party. I will file it.
I have made.
And if you have not made any party, or if you want to raise a dispute on the format part and all that, please do it now. We don't want to have it hanging on 8th. Please.
Respondent number 2 is the informant.
Everybody is there.
On 8th.
Heard, Mr. B. Goyal, Learned Counsel, paying for the A. Goyal, Learned Counsel, paying for the petitioner. Also heard Mr. B. Gogoi, Learned Additional Advocate General and Standing Counsel. Your Standing Counsel?
Yes, taxation. Finance and taxation.
Finance and taxation, full stop. After the matter had been heard, had been argued for some time, comma. It appears that the response of the respondents would be necessary to consider the interim prayer of the petitioners, full stop. Accordingly, on a request made by the learned by Mr. B. Gogoi, learned counsel, comma, who assures that the responses would be filed on or before the 3rd of September 2026, comma, list the matter again on the 8th of September 2026 when, on which date they,
Part a hearing, otherwise we'll have to start again. Only that part I will show, otherwise, my lord, we have argued on the legal issue. my lord.
that is why we initially said that after arguments had been made. So it will come up before us. It doesn't look good if we tie up some of the matters.
No,
It'll
my
come
lord,
up automatically.
criminal petition only.
It'll come up, it'll come up. We took a writ petition yesterday because we had said after arguments had been heard. So list the matter again on the 8th of September 2026. Full stop.
The other case, my lord, I will place the case diary on text.
এই দুটা হ'ব ক্ৰিমিনেল পিটিশ্যন দুখনত ঠিক আছে এন্টিচিপেটৰী বিলটোত লিখিব list this matter again on the 8th of September 2026 the learned Mr. B. Gogoi learned counsel learned additional AG has submitted that the case diary has been received and the matter can be considered together along with criminal petition number 1154 of 2026. We'll have it on 8th. আৰু এখন আছে নেকি ৰব পৰমজিৎ সিং Yes, sir.
My lord, that 4250 and some ghost witnesses, whose name?
Yes, sir.
So for 41, 42, madam, I don't see, madam, any violation, madam. My learned friend may explain how it is violated, then I could reply, madam.
My lord, may take up the NDPS Act for a while.
If you can explain.
NDPS Act. Okay. Yes.
My lord, may kindly come to section 42.
Yes.
If he has reason to believe from personal knowledge or information given by any person and taken down in writing. If he gets an information, he has to take it down in writing if it's a prior information. Now, my lord, in the instant case, my lord, the FIR says he has got the information is from a reliable source. Now the information has to be he has to reduce it in writing. Now I don't find anything on record where this information was reduced into writing. They say some GD number. That GD number is also not been a part of the TCR, number one. And number two, that GD number and the GD number which appears in the FIR format are completely two different GDs with two different dates. So where is that?
Were you not here yesterday, Mr. Goswami, when this matter was heard on these lines?
Only GD number. If only that is the expect, my lord, then I can reply. Only that is the. My lord may.
He is saying that you had to
number,
record, you had to take it down in writing. You refer to a particular GD number that it is
Yes,
GD
that I
number
will-
12 of 510-2025.
Sir.
What is
My
510-2025?
Lordship may kindly say he has shown the section 42, my lord.
Hmm.
Lordship may kindly take up section 42, my lord. What
Hmm.
is it, my lord? Under power of entry and search and arrest without warrant or authorization.
Wow.
Now, my lord, what FIR says, my lord.
Please.
Lordship may kindly see the second paragraph. Second paragraph. My lord. The information received suggests likely operation of entry and search will continue even after sunset. Accordingly, such and such issued me a written authorization. So that is a case of 41. So now, so my lord, the other things that it has to be written, it has to be sent it within such and such hours, that will not be, my lord, applicable at this stage. My lord. So, my lord, and another thing I would like to submit, my lord, this lordship is taking place at the bail stage, my lord. And honorable court has, my lord, time and again stated that on the stage of bail, you just see the whether it is a prima facie, the things are there or not. Whether if you object it or if you have any reservation to that, you have to prove it in the trial. You cannot conduct a mini trial. So
Now you
I-
have shown us
so
the
my lord,
authorization.
So my lord, authorization is in the, my lord, flag mark that is in the, that is, and first part I say that there is, since a information has been received, he is to go to a search and seizure. According to section 41, he was given an authorization. Accordingly, he proceeded to the place of occurrence and found the unconscious possession of those cough syrups.
Mm.
In that case, my lord, my humble submission is 41 is complied with, my lord. As of now, my lord. Whether if they rebut it, that is okay, my lord. If you can make it, my lord, that is the process of trial, because it is a question of fact, my lord. It is also a question of fact, my lord. Whether authorization there or not, whether it is given, that has to be determined at the time of trial.
Now, how do you explain this FIR number?
Yes,
Or
only
the
GD
GD
number, my
number?
lord. In my humble submission, my GD number 12 is, my lord, everywhere. Only thing, my lord, it is a GD number 12, my lord. But in the
Front page, it
slip-
has come up as 16.
yes, in the slip,
Maybe
my
a
lord,
typo.
the slip it is in, but in everywhere, my lord. Even in the witnesses, even in the authorization, even in everywhere, it is 12, my lord.
Okay, done.
That is. And
Yes,
if
sir.
you-
That is
if
your
you-
41. Next.
Next, my lord, they say, my lord, regarding the section 50 is a violation. But so far, section 50 violation is there, my lord. It was, the contraband was, my lord, recovered from the dicky of the car, my lord. So that section 50 goes, my lord.
But did you make any body search?
No, body search was not made
No
as
body.
per the seizure witness.
Then?
So that is that part done, my lord.
Hmm.
And regarding, my lord, they said that in 36, my lord, some witnesses were recorded, my lord. Those witnesses are not part in the trial, my lord.
The
That is not-
persons who had seen the arrest
in the arrest
are not there in the
that
not
there
there.
is not a mandatory provision that you have to make those as a
Whether the arrest was correct or not, whether those persons were there, matter of fact.
that is the difference. So you cannot say that those persons are not and they are not human. He says that some words has been used, my lord, that my lord, like alien type, my lord. I could not understand, my lord. That they my lord, so they may be, my lord, human, my lord. I am not saying that it is not mandatory that it has
Understood.
to be in the PWs, my lord.
Yes.
What is the PW, whether the seizure witnesses are there and whether the IO is there, that is, and the my trial is continuing, my lord, and at this stage of evidence, my lord. If now, my lord, we will determine anything, my lord, that will directly hamper the, my lord, outcome of the trial, my lord. And it has come out from the mouth of the, my lord, from the observation of the learned Honorable Apex Court, my lord. If you have to determine through the evidence, you have to only see the whether prima facie thing is there or not.
Okay.
And the second thing is that, my lord, in my humble submission, it is a case of, my lord, commercial quantity. And without satisfying itself, without satisfying itself, that commercial quantity, whether he is guilty of that, is a prime aspect which the court has to consider while considering the bail stage, my lord. Because this is, and time and again, I am saying that this is at the stage of bail, my lord. So prima facie, if it is there, then it is there.
Okay.
You can rebut it, my lord. And
Later
now
on.
another thing is that section 35 and 54, my lord, that initial burden, if you are my lord, apprehended with a certain contraband, my lord. Now you have to say, my lord, that burden is upon you. And that burden, how you can, my lord, discharge? It will be discharged at the time of trial, my lord. Burden is upon you to say that those contraband were not found from your possession. This is my family. So at this stage, my lord, since trial is going on, that maybe, my lord, logical conclusion, my lord.
My lord, either of the two can be correct. Either his submission that at the stage of bail 42 cannot be looked into can be a correct proposition of law, or the law laid down by the Honorable Apex Court in 2004 12 SCC 236 para 7 can be the correct proposition of law. Both cannot be correct, my lord.
Both sides there are laws, my lord. There are also law which there are also
Mr. Goswami,
that says, my lord.
Mr. Goswami, we have requested all councils not to interfere when
Lord.
someone is making a.
Lord, I'm very sorry, my lord.
He will try to have all things out of you here itself. Don't allow that. Sit down when he's arguing.
Look,
Yes.
so if he, then I can say.
No, we can't go on like this. You have had your say, he has had his
Yeah,
say.
he can say.
You gave a reply, I'm just giving him some time to say what he has to say. Yes.
Yes, my lord. 2014 12 SCC 266.
Come to 41, 42.
Now, my lord, 41 and 42 are two independent provisions. 41 is with regard to authorizations. 42 is when an authorized police officer gets an information, he has to reduce it in writing.
And gets an authorization to go ahead to do it.
But that is authorization is under 41. 41 will not dispense with the requirement of 42. 42 and 41 are two absolute independent provision.
Done. Next.
Now, my lord, they say that in every place there is a GD entry. Now, my lord, the GD entry is the best evidence. They are saying prima facie. I am saying, yes, let it be a prima facie satisfaction. Where is the GD entry? It cannot be some, my lord, some ghost paper which they have, because there is no GD entry in the TCR.
Understood.
They are just throwing some numbers. And they are, if we go by their own record, that the font page, it clearly defies. Now, my lord, as far as section 50 is concerned, my lord, there is because my lord, your lordship is well aware, my lord, the law is settled that whether the contraband is recovered from anything attached to the body or from the vehicle or from any, my lord, I mean, any bag, or it may not be attached to the, may not be from his person, maybe from something which is a bag which he was holding. But even in those cases, if the body search is done,
that is what I asked.
that is precise, my lord. His notice say, their notice say that the body search. My lord will kindly take up there.
They gave you a body, notice for body search, they did not search you.
No, my lord.
That is his stand.
No, my lord, that stand, my lord, then that is, this is a redundant exercise, then police, then all exercises, they are cherry picking.
If they say that I have not body searched him despite the notice, I cannot go into it right now.
Now, my lord, I have said that I have been body searched. Their document is showing that they have issued a 50 notice. Now, my lord, all these facts indicates, now if at all there is two views possible, then my lord, to whatever little I understand, my lord, the view favoring the accused will go, because their prima facie document says, I do hereby inform you the provision of section 50. And then according to this notice, I said, because these are two contradictory statements. First, they say that I have agreed to be searched under 100 CRPC. Second, they say I have agreed to be searched before the magistrate. Neither here nor there.
And you sign on a piece of paper which is neither here and not there.
Not there. Because I am in police custody.
Oh, so you'll sign everything?
My lord, I have signed, so that testifies that I have opted for this to be searched. And moreover, my lord, the right has to be, no, if I have signed, even that goes in my favor, that I have signed for this also, two also. Now, these are the precise things where, my lord, where an argument can be made that these all signatures, they are optionless than to make these signatures, whatever printed from they are giving. There is, my lord, they say that 50 NDPS.
This is where the difficulty arises. Your bail petition says nothing.
No, my lord, the additional affidavit is there, my lord.
It says nothing.
Additional affidavit is there.
Saying what?
My lord will kindly see. Running page number 30.
These were after the matter was heard for some time, and
31, my lord.
Bookings
So
of
those were
court.
filed, my lord, those were bought on record, my lord. They have got an opportunity to
You
rebut,
did
my
not,
lord.
you did not amend the bill petition, did you?
I have supplemented my argument. I am not contradicting my other.
All right, we'll pass our orders in the chamber. You're rejecting it. Bill petition is rejected. Orders to follow.
Additional affidavit is there on record.
Yes.
My submissions I have recorded in the additional affidavit.
Everything will be there on our record also.
With the lawsuit's permission, it's a lawsuit permission, I'll submit one judgment because he said that.
Not after he finishes his arguments. We have other cases to look into. Yes, item 76.
So it's mine.
Yes, sir.
There are two ladies before your lordships, my lord. Here, what has happened, my lord? There are two ladies, my lord. The elderly lady, my lord, who has been arrested, her son was married to a lady, my lord.
Okay.
Wife, my lord. This wife lodges this affair, my lord. And her son committed suicide because of atrocities by this first informant, my lord. My lord, when the son died, out of these two applicants, my lord, the mother, my lord, she lodges an affair before the concerned endemic police station, my lord, that whatever be it, my lord, abatement in commission of suicide, my lord. They received it, kept it pending. Till date, that has not been registered. Now the lady has come up with the present affair, my lord. May I just read it, my lord? I'll read both the affairs, my lord. And the ladies were arrested at night without following the due process of law, my lord. And all 5-year offenses, my lord, all are bailable, 7 except 1. And that is also 5 years, my lord. May your lordship look at page 21, my lord.
Scene.
21, my lord.
21 scene.
I'll be very cryptic, my lord. Para 2, my lord. That during marital life, my mother-in-law, namely Rubina Begum, she has been arrested.
The allegation is that they had some photographs and they circulated it.
Photographs,
Intimate photographs, whatever photographs.
Yes, my lord.
They have circulated it. Any other allegation? No.
No other allegation. Then no other allegation. And my lord, secondly, kindly
Where
see,
is
my
your FIR?
my exactly, my lord. My affair is at, my lord. 43, my lord. 43, my lord. This is lost prior in point of time, my lord. Definitely the husband expired prior hand, my lord. Page 43, my lord.
43.
43. This, my lord, we have to now, we have come to know about it, my lord. Sorkari Boso has to be resorted to, my lord. Because, my lord, they have not registered it. Can they do that, my lord? Cognizable offense. They cannot do that, police. At same police station, this lady lodges the case. There are allegations against her as to abatement in commission of suicide, this affair, prima facie, ex facie, my lord. Now she lodges an affair that her photograph with her husband, my lord, and husband happens to be the lady's son, my lord. And here are allegations that she was having an affair with somebody else. And we say that the photographs belonging there belong to the other man, my lord. Those are immaterial at this stage, my lord. What I am saying, I lodged an affair alleging a commission of a cognizable offense. My lord, kindly see the receipt part of it.
Circulated her photographs through mobile, email, etc. Yes?
Okay, as per para to photographs were uploaded and subsequently husband died.
Now, these sections which are leveled against her, barring one, all
bailable, my lord.
That is there.
Heard Mr. Mahajan, learned counsel appearing for the petitioner, assisted by A. Chaudhary, learned counsel for the petitioner, full stop. Also heard Mr. K.K. Parashar, learned APP, full stop. This is an application for praying for grant of bail. Grant of regular bail under section 483 of the BNSS to the petitioners. Who is the second one?
Second one is her relative, my lord, to whom the mother sent that message, my lord. She circulated it, my lord. Sister-in-law, my lord.
One is mother-in-law and one other is sister-in-law.
To the petitioners, who are the mother-in-law and sister-in-law of the informant respectively,
in connection with Jalukbari PS case number 332 of 2026, registered under section 61 within bracket 2 to Siloba, huh? So and so the petitioners were arrested on 23/8/2026. Mr. Mahajan, the learned counsel for the petitioner, has submitted that the petitioner number 1 had informed the police authorities of Jalukbari police outpost on 21/1/2026, leveling allegations that the death of her son by suicide was abetted by the informant in the present case where the petitioners are seeking bail. Full stop. By drawing attention of this court to the FIR lodged by the informant against the present petitioner, he has submitted that the only allegations which are leveled against the present petitioners are circulation of some intimate photographs of the informant therein. Full stop. He has prayed that the further custodial interrogation of the petitioners may not be required, as the circulation, etc., would be matter of electronic evidence which would by now have been recovered by the investigating authorities. Full stop. Mr. The learned APP has submitted that the case diary of the investigation would be made available on 17th of September 2026. Full stop. Having regard to the facts and circumstances of the case and to the fact that both the petitioners are women, and further that the allegations are only of circulating and the allegations are of circulation of photographs, comma, I am of the considered opinion that the further custodial interrogation for the present with regard to the petitioners may not be necessary, and the petitioners can be allowed the privilege of a bail awaiting the CD. Full stop. Accordingly, it is directed that the petitioners shall be released on bail on each furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of
Lane Chief Judicial Magistrate, Kamrup Metro, my lord.
Lane Chief Judicial Magistrate, Kamrup Metro. Full stop. The continuance of the privilege granted today shall be reconsidered on receipt of the case diary.
Highly obliged, my lord. Obliged, my lord.
May I please, your lordship? For 82 pre-arrest bail application, case diary was called for, your lordship.
Has it been received, sir?
Yes, madam.
You are what?
I'm not a shopkeeper. I'm the customer of beef, your lordship. They have alleged to me be a shopkeeper, alleging 5.825 kg suspected beef was recovered from my shop, your lordship.
Okay, you are accused number 1.
Accused number 1, your lordship.
Yes, sir.
Admittedly, my lord,
When were you arrested?
not arrested, your lordship. Pre-arrest bail, your lordship.
He can go and appear. Let him show the source. Maybe he can show some good source from where he got it.
He'll cooperate.
Huh?
He'll cooperate, your lordship.
No, you have to show the source. We need the source for all kind of meat. Even those hanging in other shops without the seal of the veterinary department. From where do they come? Mutton and all without the seal. Huh? Heard learned counsel appearing for the petitioner, also heard the learned APP. Full stop. The case diary called for has been received. Case diary is received. Case diary has been received. Full stop. The investigation is still under progress. Full stop. In view of the circumstances, I am of the considered opinion that the presence of the petitioner before the investigating authority to participate and cooperate in the investigation and reveal the source of the meat found in his shop would help in the progress of the investigation. Accordingly, the petitioner shall appear before the investigating officer on or before the 7th of September 2026 to participate and cooperate in the investigation process, full stop. In the event of his arrest before the next date of listing, the petitioner shall be released on bail on furnishing a bond of ₹10,000 with one surety of the like amount to the satisfaction of the investigating authority. I call for the updated CD list again on the 24th of September 2026.
Oblige.
Morning I have mentioned for unlisted my lord. Because of some medical urgency, my lord. Your lordship may kindly see the FIR, my lord, first.
Medical urgency.
His son, my lord, his son is in my critical condition, my lord.
You said so. Yes, yes. Where is the FIR?
FIR, my lord, see, my lord, kindly see page 10, my lord, that's my lord, type copy, my lord. In the content of the FIR, my lord, one person name, my lord, that
We
is,
remember this case. It came up when?
my lord, no, my lord, first time, my lord.
Use of the biometrics.
That some other co-accused possibly, my lord.
How many co-accused are there?
Not one person name in the FIR only, my lord.
You.
No, my lord. Jewel Ahmed, one, my lord.
And who are you?
My lord, what happened, my lord? One of the co-accused, my lord, Junaidur Rahman is arrested, my lord. He is the friend of petitioner number 1, my lord. Sometimes there is some phone conversation, my lord. Possibly on that ground, possibly the police visited the house of the petitioner on 18, my lord, last week, my lord. So, my lord, they are afraid of my lord, arrest, my lord. They approach this honorable court, my lord. Otherwise, nothing in the FIR against these petitioners, my lord. And petitioner number 2, my lord, his son, my lord. We will also kindly say, annex the medical documents, my lord. Page 21, my lord. 10 months daughter, my lord.
What is his name?
My lord.
What is his name?
Daughter, my lord. His daughter, my lord.
Her daughter. What is his name?
Irfan, my lord. Taslima, my lord. 10 months age, my lord. She has, my lord, 2 millimeter, my lord. In page 21, my lord. RA, OSHD 2 millimeter, my lord. Hole in her heart, my lord. And petitioner number 1, my lord. He, my lord, prepared in the, my lord, B.Ed 4th semester exam, my lord. That are annexed, my lord, documents, my lord.
Why do I remember this case? We will have it after some time. Go by the PSK's record, find out if another petition is pending. Yes. You are here for whom?
Nozmul and my lord. And Ilyasuddin, my lord.
Ariful and Firoz, I don't know who was here. I had told the petitioner that go and get some updated medical educational certificates. These are not helping you. I remember that part. Same university. The same university was involved. Baba Saheb Ambedkar, yes, of the year 2024. Now we don't know if. Yes, this is also 2024 first semester.
First semester, that mark sheet I have given that I am the student of that university, my lord. And my lord, to show, my lord,
you passed first semester in 2024.
My lord.
You have given nothing of 2026 that you are continuing your studies.
That, my lord.
Admission?
That mark sheet, my lord. That
admission?
Admission is
in 2026?
Exam schedule I have given, my lord.
Where? Exam schedule, where is your name? Where is your name?
That's why I have given the mark sheet to show that I am the student.
One we will consider. In the morning you said that the child is suffering. I need that listing because of the child. We are allowing the child.
Kindly see, my lord. No,
we will allowing the child.
Nobody name in the affair, my lord.
We will ask them to find out the next date. You will come back on the next date.
My lord,
we will not consider anybody.
Will appear, my
one of them.
And record our statement, my lord.
The person with the person whose child is suffering,
my lord.
We are believing that you also find out from your IO whether this certificate is genuine or not.
But
till that time, can you find out AB here too? AB 2001 of 2006. KTSS 2026. AB 2278 of 2026. Egita section. Next day, we'll have it after some time. I'll
My-
pass the other. We are allowing for one only.
I'm praying for both, my lord. Because nobody named in the FIR, my
A
lord.
better educational certificate would have helped you.
My lord, I am not taking that plea, my lord. If my lord, on merit, my lord, your lordship
Item
may kindly-
84. Item 84.
After some time.
Met you, Lordship.
Ah, yes.
Here, Lordship, on first day, I had said that 48 notice was not served to the family members.
That part is solved.
That, Lordship, I have also got some documents, so I am not going to into that dispute, but it is all documents of he is resident of that area. But other grounds are there, so I am not going to into that disputed fact, Lordship. Now, say, 36 notices there, Lordship will find page 23. No
23.
signature, yes. Signature of witness are not there.
Hmm.
And apart from that, he was produced before the magistrate beyond 24 hours.
That is the only thing that we now need to
And
do.
here, in fact, if your lordship see the CGR list, which I could not annex, so it is on record, lordship. CGR list was prepared on 24/4/2026 at 1:12 p.m. lordship, daytime. And he was served with a copy of under section 47 notice at next day morning at 11:15 p.m. So if we go by that Mihir Raja sir, lordship, that within prior to 2 hours, he has to serve the notice. So they have only a small window of lordship that from 11:15 to 1:12 they have produced. So they have to show that within that period they have produced.
That you moved
Yes.
from the police station. You have ordered at 24/8/2026. What time did you move?
My lord, that is, I have verified, my lord, not found, my lord, on what time they have moved to the, my lord.
From where did you find?
Not found, my lord.
From where did you verify?
I verified the record, my lord.
Last occasion we had adjourned it, asking you to verify it from the station. They would have a GD entry what time they moved. Huh?
But CD, original CD is here, my lord.
This one?
Yes.
CD, no, that part.
In the record, originals are there, lordship.
Where?
With the records, lordship.
Record.
TCR trial court.
There is no GD entry that they had moved at such and such time.
Found, my lord, I have not.
The police station is moving around under trials or accused without any entries.
And here also that contraband were recovered from bus stand, lordship. He was hired labor, he was standing there. And
He was hired labor to carry the contrabands.
No, not contraband.
No,
He
not
was-
the
the bus stand.
some
he
other
was there.
luggage. Some other luggage.
Yeah, lordship.
Huh? It is not there. So when you are not being able to show for the last 2-3 days that it was done within the 24-hour window, what option do we have? That is a different issue. That is the and the police are not giving. There is nothing on record to show that this is the time we had moved. So some time ago we were told that the benefit of doubt has to go to him.
What?
Huh? Hmm?
Yeah. So next day, if produced before 1, then okay.
But you gave him the 47 notice at 11 o'clock.
At 10:15.
So he was already in your custody for around 22 hours without there being any record of his being in your custody. Huh? Heard, Mr.
Yeah.
Yeah, Ahmed Learned Counsel appealing for the petitioner. Also heard the Learned APP. Full stop. Scan copy of the TCR is available. Original.
Because I have been told also in that court that Xerox machine is not functioning. Even I have applied for certificate that is also not provided for last 20 days.
The TCR call for Although the scanned copy of the TCR was called for, comma, the entire TCR has been, original trial court records have been received by this registry, full stop. The learned counsel for the petitioner has submitted that the petitioner had not been granted the privilege of being the petitioner did not have the privilege of his ground of arrest being informed to his friends, family, and relative as required under Section 48 of the BNSS. However, on a perusal of the report submitted by the learned APP, this court is of the view that substantial compliance of Section 48 had been done. We are not saying what happened and what not. The learned counsel for the petitioner thereafter submitted that the arrest memo of the petitioner did not contain the signature of any independent witness, and has further submitted that the petitioner, having been taken into custody at about
Seizure list was prepared at 1:12 p.m.
1:12 p.m., when the seizure list along with the contraband had been prepared
on 24/4.
on 24/4/2026,
Here, sorry for interruption, Malad. Another seizure list, Malad, that is also found, Malad. It is 25/4/2026 at 9:50 a.m., Malad. There's mobile seized from him, Malad.
only the mobile. The rest of the things he was there. We'll record that. The learned counsel has submitted that the petitioner was thereafter produced before the learned remand magistrate in the evening hours of 25/4/2026, and he therefore submits that the window period of 24 hours as mandated in law having been surpassed, the continued detention of the petitioner after 24 hours of his arrest had been rendered illegal, and the petitioner would be entitled to the privilege of a bail. Full stop. Mr. B. Sharma, learned APP has submitted that there is another seizure memo which was prepared at 9:05 a.m. on
25/4/26.
on 25/4/2026, showing the seizure of a mobile from the petitioner. He has accordingly submitted that if the second seizure list is taken into consideration, the production of the petitioner would be within the 24-hour window, full stop. On a perusal of the case records, we find that the petitioner had been apprehended along with had been allegedly apprehended along with the contraband on 24/4/2026. And the seizure list had been prepared immediately after the seizure procedure had been completed, full stop. Therefore, in view of the settled law by the Supreme Court, I am of the considered opinion that the petitioner had been taken into custody on 24/4/2026 at about 1 o'clock in the afternoon, full stop. The records do not reveal, and further, the learned APP has not been able to show from records supplied to him by the arresting / investigating authority that
No,
the
record is there.
no. Listen to the full sentence, sir. Has not been able to show from the records provided by the investigating authority / the arresting authority that the petitioner had been presented before the remand magistrate before the 24-hour window had elapsed. In such view of the matter, and also keeping in view that the arrest of the petitioner had not been witnessed by any independent witness, I am of the considered opinion that the further detention of the petitioner has been rendered illegal in the present case, full stop. Accordingly, the petitioner is granted the privilege of bail. And shall be released from custody on furnishing a bond of rupees. What was recovered, sir? Cough syrup,
Syrup, my lord. Cough syrup, my lord.
huge quantity.
Huge quantity.
Bond of rupees 50,000 with 2 local sureties of the like amount to the satisfaction of
Special Judge Kamrup Metro.
Special Judge Kamrup Metro. Full stop. The learned Special Judge Kamrup Metro shall be at liberty to impose such other conditions as may be required to ensure the presence of the petitioner during the trial. It's charge sheeted, yes. During the trial, full stop. The petitioner shall not leave the territorial jurisdiction of the learned trial court without prior written permission. Full stop. The petitioner shall not indulge in any activity of the similar nature during the period where the bail remains, during the period of bail, full stop. Any violation of the terms and conditions would entail cancellation, recall of the bail granted today. Be disposed of. की है? हाँ? हाँ, डेट टू पैसे नहीं की? Yes.
No interim granted and fixed on the 3rd of September. And one BA, it is fixed on 31st.
31st. So 31st we can also have on 3rd of September when it comes up. We'll allow him to appear. The petitioner number 1 who has got a child in distress. Huh? Heard Mr.
2, my lord.
Eh?
Petitioner number 2.
Okay, petitioner number 2. Heard Mr. S.M. Mullah, learned counsel appearing for the petitioners. Also heard learned APP. Application under 482. Tejpur PS case number so and so. The learned APP has submitted that bail application number 2278 of 2026 is pending before this court, full stop, and has been fixed on 31/8/2026. 31/8/2026, where the CD has also been called for, full stop. The learned counsel for the petitioner has at this stage submitted that the petitioner number 2 has a minor daughter aged about 5 months.
10 months, my lord.
About 10 months, who suffers from critical heart deformity and requires constant medical attention and presence of the petitioner, full stop. In view of the above, it is directed that the petitioner shall appear before the petitioner number 2, namely so and so, shall appear before the investigating officer on or before 29th,
Yes, my
day
lord.
after tomorrow.
They are from Morrigan.
Yes, you send them the information. He will inform the investigating officer. The case will come up again on 31st.
Yes, my lord.
You have to appear before that.
One another AB is there, my
3rd of September. Once the CD comes here, no use you're appearing there,
lord.
is it?
31.
So appear before on Friday. Or appear on Saturday. Appear before the investigating officer on or before the 29th of August 2026. Full stop. In the event of his arrest, he shall be released on bail on furnishing a bond of rupees 5,000 with 1 surety of the like amount to the satisfaction of the investigating authority / arresting authority. Full stop. List on 31/8/2026 along with BA number 2278 of 2026.
31/8, my lord. Next day. 31/8, my lord. Next day.
List on 31/8, yes. You appear on Saturday.
My lord, today if I get the copy, my lord, certified.
Huh?
Yeah, possibly I will not get the copy, my lord.
If you have the time, apply now.
After
You will have it at 4:30. It would have got my idea.
sir, 3:30 will cannot.
Huh?
Sir, 3:30 apply karibo na.
After 3:30.
Okay. A copy of the order shall be handed over to, shall be supplied to the learned counsel for the petitioner and the signatures of the court master to allow the petitioner to appear before the IO as directed.
Bless, man.
Go. ATM ID will do ATM ID will do ATS ID. Item 16, yes.
May please, your lordship. Criminal revision petition, lordship, arising out of NIAC proceeding.
This is for admission.
Lordship. Whatever in this case, lordship, the trial court convicted the petitioner under 138 of the NIAC, lordship. And lordship sentenced to undergo RI for 1 year and pay a fine of rupees 5 lakh with in default of payment of fine to suffer SI for 2 months. On appeal, the conviction was affirmed, lordship. This is a revision petition. After filing of this revision petition, the petitioner got arrested on the strength of NBW, lordship. Thereafter, lordship, the matter has been settled between the parties.
Settled.
The 5 lakh has been paid to the respondent. And respondent has also filed an affidavit stating that the acknowledgement, lordship. Since the matter has been settled between the parties, this revision petition
You
can be
don't
allowed.
want him behind bars for 1 year.
Yes, lordship.
You don't want him behind bars for 1 year.
Been compensated, Your Honor.
You have been compensated enough. We'll close it.
Yes, sir.
Set aside the imprisonment part.
Yes, set aside the imprisonment part and setting the petitioner at liberty, lordship. She is behind the bar now.
She.
She, lordship. Both are ladies, lordship.
Since when? Since when?
Since
behind bars?
31/7.
31/7.
2026. This is the order I put.
Why it has to go to so much of coercion for payment of that 5 lakhs? It could have been done days ago.
At the earliest stage, lordship.
Huh?
At the earliest stage could have been done, lordship.
What is that?
This is the order of arrest, lordship.
Dix.
Subsequent to filing of this petition. The original, lordship. On the strength of NBW, lordship.
No, this is for NBW, issuing the NBW.
This is lordship. Same day, lordship. That was for issuance of.
Okay.
One judgment passed by the coordinate bench of our High Court, lordship. Similar, lordship.
Since the money has been paid,
And
please close it up.
lordship. In that case, he was not taken to custody. He was outside.
Okay. Editor, Ekita, give us photocopy of this.
Photocopy I have, lordship. I have the photocopy also. Original can be kept, lordship.
We are disposing of the petition. We are disposing it of. Set at liberty.
Yes.
Tomorrow.
Lordship.
We'll pass the order today. Tomorrow you'll be set at
Lordship.
liberty. Okay. It is
Highly
disposed of.
Problem.
Informant was issued notice. My learned friend appears for the informant. PCI has been called for. I think PCI has also come. And we have challenged the order at page 72.
72.
Which rejected our prayer for recall of the witness, which is earlier it is 311, now it's 348.
Yes, sir. What is the problem in recall of the witness for for further cross?
Victim, my lord, if she consents, then I don't have to go to the merit. If the victim agrees for her examination, we'll do it on one day and finish it off.
Hmm.
Your lordship may fix the date, will not seek for any.
Who appears for the victim?
I'm for the informant, lordship.
You're for the informant.
Informed victim.
Tell us.
Lordship,
You are going to have someone sent behind bars. He wants to cross you some more
lordship.
before the others have finished. PW2, 3, everybody stayed. Yes? You are the only person. He could not complete it for some reason. Do you fear? No.
Lordship, as per my instruction, lordship, the respondent number 2, lordship, leaves the matter, lordship, up to you, lordship. As lordship, as lordship decided, lordship, if lordship directed to appear again, lordship will appear.
Okay. Yes, Mr. PP. Tell us any bar.
Regarding the, if there is a victim, my lord, a my lord, minor age, my lord, he should not, she should, there are
Not be
some-
subjected to examination,
Yes,
cross-examination repeatedly.
that is
Now,
one part.
they have cross-examined once possibly.
They-
Some more cross-examination remained, and there is a single location they are asking for 1 day.
Whether, order, whether this ground, my lord, taken by them is for the filling of lacuna or real cause for the ends of.
They have to give a questionnaire.
That is.
Is it not?
No, my lord,
Oh, yes, yes.
my lord, there is
There is something like a questionnaire that has to be given so that the court can
Yes.
consider.
my lord, so far the filling of lacuna concept is concerned, it is applicable only in case of re-examination by the public.
That is
prosecutor.
it. Even in cross-examination.
But in
Even in cross-examination, once you close it,
yes, ma'am.
to reopen it, the same principle according to us would apply.
No, yes, we have.
If you are trying to fill up lacunas left in the cross-examination, we are not
my lord,
convinced to do it.
there is one judgment. Sure. My lord, we are all in the process of learning daily.
True, true.
It says that the filling of, it's ultimately this provision only talks about for the end of justice.
There was some provision. What is that where you are required to put forth the questionnaire and the court then considers whether these are the questions which are required, where you are required to allow you to cross?
Yes, my lord. There, now in the application, my lord, we have to state on the points on which we require,
Exactly.
which we require that there is no dispute about. Here we are saying that we only require to put the contradictions and some of the.
It is not, it may not be for the other party to see
Yeah, lordship.
before the cross.
Yeah.
Without the other party to see,
Your
at least it
lordship
should be
will
before
see,
the court to consider.
Yes, right. Your lordship will see paragraph 15 at page 12.
Paragraph 15, page 12.
In the next page, we have put those within inverted comma. And here, my lord, the father has been declared hostile because he said that there was land dispute and all. But that's why, and they were examined on the same day. That's why probably these lapses were there due to the oversight, my lord. Now it's at the IO has been there. We are not recalling. IO is fixed on next third. On the third, my lord, if my learned friend appears on third, we'll examine the victim on third. Then immediately on the next date, we'll finish the IO, and because here the father, who is the informant in the case, the father has not supported the case of the daughter because he said that the son. PW2. We have given the statement of the PW2. Your lordship will find a page. At page 61.
Yes, Mr. Goswami, kindly go through this paragraph 15.
12.
Paragraph 15.
12.
Tell us whether we can.
Because here, my lord, your lordship is right. Since the consequences are disaster, 20 years. So one opportunity will not cause prejudice to them. And we have to put the questions through the court only. We can't even ask the child directly. So here, that no prejudice will be caused to the any of the parties. Your lordship will look at page 61. Your lordship may also look at page 59 also. PW1, mother. Mother. Fifty-nine to 59. One did not is the informant, PW2 is the son.
Is the evidence of the PWs given here?
Yes, yes, all. Page 59 is the
Victim.
victim is at 61. PW2. Actually, my lord, tutored witness, but your
No,
lord.
we are not on that. We are just trying
61.
to see, the question you want to put is what kind of a bad act was done by the accused.
My
That
lord,
is already answered in the examination.
no, my lord,
Page
my lord,
76.
it is 61 of the question to put answer.
Page 76, second paragraph.
My lord, your lordship, there is one more procedural lapse. Of course, when you put a questions to the victim, first the test has to be done.
That will be
Because
for
here, since the victim is 12 years, that's
that
why
will-
probably the test was not done. Probably that's why the test was not
It will
done.
only be done if the magistrate feels that it should be tested.
Yes, sir. No, if it is less than 12 years, then it's mandatory. But if it is 12 years, probably that's
It
why
is left to his option.
now you'll also see the paragraph which I have referred at page 12 and this which is there at page 61. Only we want to put those questions, your lordship may indicate.
The questions that you wanted to ask is what kind of a bad act? That has been explained by the petitioner by the victim very clearly in page 61.
My lord, now in view of the informants who and the son who were examined on the day, that day.
That cannot be a ground, sir.
No, my lord.
How can that
no,
be a
my lord,
ground?
this is the
You examine a witness when he's before you.
Now, your lordship.
Someone says something
Yes.
later on. Can you
Yes.
go back to that witness
No,
again?
but why we will go back, my lord, because your lordship will look at the evidence of the doctor now.
Depending on the evidence of the doctor, can you go back and call back a minor witness?
No,
Cannot.
that's why we want to put it, my lord, because at the time, my lord, the doctor was not examined. Your lordship will see the doctor has evidence at page 66.
Because of something other witnesses have said, we will not allow you to cross-examine a minor child who has already gone through an entire trauma, possibly.
My lord, your lordship, see, the informant has said, this is not one of those cases where the mother and father who is the informant has not supported the case.
That will be a good case for trial, sir. Would that be a good case for allowing a re-cross-examination of the victim?
No, we only want to put the contradictions, my lord, because these are the first time uttered in the court.
I'm sorry to say, sir, I'm not convinced
Well,
that
then-
in this situation, I can allow it.
Lordship will say, after all, it's the inch of justice and a fair trial.
True.
If your lordship goes it by this statement, this person is going for 20 years in jail.
No. What
But
I am
at
saying
that
is, that you want to put a contradiction to him.
Yes.
That is one part of what he might have said before someone. You want to contradict him with that, it is different. You want to contradict him with the statement from the doctor. That we cannot allow now.
Doctors, your lordship will ignore it, but contradiction part.
Now at paragraph 12, you say, your petition says that we want to ask him what kind of a bad act, basically.
No, your lordship will say page 13.
All the above statements were either absent or materially different from his earlier statements. But the same could not be duly confronted with so-and-so. Look at this thing. And the order of the trial court. In the case in hand on close scrutiny of the testimony of so-and-so, it is our sin that the earlier engaged counsel had cross-examined. We are not on that. We'll even let that go. Now, Page 77.
My lord, my lord, I-
Recalling application is unsustainable as the victim has clearly explained what the bad debt was done on him. That was the application moved before the trial court.
my lord,
That was the application answered by the trial court.
my lord, trial court has answered to my application, but the
Yes, sir.
trial court has ignored that even the court can't be a mute spectator when they see that certain things were not put, because the court has also to play a contributory role. Here you are sending, huh?
So the trial
Then
court
your
has
lordship
gone,
will
trial
say-
court has gone far ahead than that.
Your
The
lordship-
trial court has tried to clarify,
your
put
lordship-
clarification
your
questions.
lordship will see the medical report at page 48 and 53, my lord.
So am I, am I required to allow a cross-examination based on a medical report which was not put to the petition, put to the minor victim when he was available?
My lord, with utmost respect, my lord,
Mhm.
theoretically, my lord, your lordship may be right that this, we had missed one opportunity when we had the cross-examination, because this cross-examination may not be satisfaction to my satisfaction. Just because as the trial court has said that just because there is a change of counsel, you cannot have the.
No, we are ignoring that part.
But your lordship will say that only we are asking today is one opportunity before you send this person to 20-year jail on the basis
Only
of the.
then the only question that you will be allowed to ask is what was that bad act?
My lord,
That
this-
is what you prayed before the trial court. That is what we will allow. What
lord-
was the bad act is the only. No further cross-examination.
And the
No
supplement,
cruel scoring.
no, and the supplementary questions to that bad act, my lord.
Where is that?
My lord,
Where is it before this court?
my lord,
Give it to us in a seal cover. We'll send it directly to the court. Those are the only questions you'd be allowed to ask. You would not better your court. You would not be allowed to better your case by further cross-examination now.
Yes, my lord, we'll give it by tomorrow.
We can have it fixed on third, or otherwise we'll see whether those questions are questions
Third,
which can be allowed.
on third, the IO is fixed, then your lordship will defer the IO to one date, my lord.
No, you are allowed the permission, you are allowed the liberty to,
No,
on the earlier occasion.
Yes, but it was given only for one day.
We'll say that you will be allowed to
you-
ask for the matter to be fixed on some other, but this is delaying the entire thing. We are not
It's
satisfied,
not,
Mr.
delaying, my lord. My lord, what I would say, my lord, is because of the inexperience sometimes catches up. My
Could
lord,
be.
your lordship knows the ground reality. We are also to blame for it, my lord.
Sir, because of the, because of the lack of experience of lawyers in handling cases, people are losing citizenship.
Yes, my lord.
Is it not?
Yes, my lord.
People are getting behind bars.
Yes, my
It
lord.
is the people's choice to have a lawyer of their counsel,
My lord,
lawyer of their choice,
My lord,
counsel of their choice.
a resourceful person can have the best of lawyers, but your lordship will say the POCSO cases, this is a classic case where it has been misused.
So
by
therefore,
so
the
many-
moment you make those submissions, sir,
We'll
you
give-
are telling us
No, ma'am.
that we will have a better cross-examination. We are
Without
not
causing
allowing-
any prejudice to any party, well, we'll give the questions, we'll put in cross-examination in a, to your lordship. Then if they look it into it also, because they say that we have no objection so far if the victim is cross-examined, we'll give it. And your lordship will give us one liberty to get the case adjourned on third again, my lord.
What happened is, the trial court, it was said that we want to ask, what was the bad act? That I can allow. That I can allow right now. Go and ask them. What was the bad act? One question, over.
No, my lord, that we have to put some supplementary questions also.
That is further.
No, my lord, otherwise
That is further cross.
then we put it in silk over your third, your lordship will.
Not permitted because.
Lordship, kindly see page 70. What is the
70?
page 70? What is the application before the?
That is what we had seen. That is what had.
I also know my, my lord,
is very much, my
but
lord,
being a counsel for so many years, I also know where my hands are tied.
it is
My
not.
lord, only thing is that your lordship will allow us to seek an adjournment on
change of
third
counsel is
of
not
the
a
investigating. I know the law.
Mr. Goswami,
I know the law.
let me tell you one thing. The beauty is to realize that senior advocate's hands are not very free to fight, and yet he
Yes,
can
my
twist
lord.
it around to have an order.
Yes, my lord.
My lord,
That is the beauty.
That we
My
should
lord,
learn, my lord.
we'll seek only one day adjournment on third. Your lordship will permit just like on the other occasion. and we'll give the questionnaire to your lordships, around 10 questions. Your lordship will select which questions we can put in.
Who is the witness? Who are the witnesses who are supposed to come on the next day?
Investigating officer. Because if
Investigating
we
officer.
put the
Official witness. So
Official witness.
the cost you have to pay for
official,
his coming and going back.
he is a local police personnel, my lord.
Local or not local,
If he is a,
he charges for the day, TADA. Heard
Yes,
Mr. B.D. Kumar, learned senior counsel,
then
assisted by
P. Dolan also.
learned counsel for the petitioner, full stop. Also heard Mr. M.P. Goswami, learned APP, and learned counsel appearing for the respondent number 2, within bracket informant, full stop. After some arguments, the learned senior counsel has prayed for the matter to be taken up on
After 10th, no?
Yeah, yes, we can have it on subject to on 11th or on 18th.
on 11th of September 2026, comma, by which time the learned senior counsel submits that the cross-examination sought to be prayed for shall be placed, the questions of the cross-examination sought to be put to the minor victim to show their relevancy for a re-cross-examination will be put before this court, full stop. List accordingly on the
cross.
Not
re-examination, further cross.
further cross-examination. Okay, fine. The learned a list accordingly on the 11th of September. Full stop. The petitioner would be at liberty to pray for an accommodation in the trial proceedings in view of the pendency of the matter before this court.
Accordingly, my lord, the trial court.
The trial court shall accordingly refix the matter on a convenient date on such prayer being made.
We are deeply obliged, my lord. We are deeply. Well, ground reality is very bad. We have seen because when cases are sent back, the persons are getting acquittal. But when it first comes, we see 20 years. And in POCSO, life means he will be the entire life. So people are taking up, my brothers are taking up cases there in the trial court without even knowing the elementary of the leading questions or what is effective process.
We need more advocates attending the trial courts when actual trial proceedings are going on.
Yes,
not for filing of their hazira and taking a date.
No, no, my lord.
We need people sitting there to understand what is happening in a case. Is it not?
There is a beautiful quote said by a senior advocate of the Supreme Court. He said that trial court lawyers are like the artist and the high court lawyers are the critic. So it's better to be first to be an artist, fellow. We are deeply obliged for accommodating us, fellow.
Yes. Etu kiman kola item number 19.
May I take the notes?
Yes, sir.
In the meanwhile, your lordship, search sheet has been submitted in this case. We have filed an additional affidavit bringing on record that search sheet, your lordship. Now, your lordship, the petitioners here in your lordship are two lawyers, your lordship, husband and wife, your lordship. Now, what has happened, your lordship, to them? They, your lordship, one boy and one girl came to meet them, your lordship, and they came for your lordship registration of their marriage under special marriages, one Hindu and one Muslim. Now, accordingly, they, your lordship, took up the matter, and when they issued notice, your lordship, that I have annexed at page 22, your lordship, notice of intended marriage, that is as per the requirement. Then, your lordship, an FIR has been lodged by the brother of the girl, your lordship. That your lordship will find at page 23. And it says, your lordship, with due respect, I, the undersigned, honor to inform you that my sister so-and-so was allured by one Sikh Ali today at around 11:30 am, was forcibly taken to the court with a purpose of court marriage with the help of his family members. But in the meantime, I came to know the plot of the accused and rushed to the court immediately, saved my impending death. But knowing that arrival of the court, accused managed to escape from the court, taking my sister forcibly.
Both of them vanished.
Lordship. Now, your lordship, ultimately on the basis of this, a ZD entry was made, your lordship, which your lordship will find at page 26, and the girl was recovered, and produced. That your lordship will find at page 28. Now, the order of the
learned trial court, your lordship, when she was produced. Now, your lordship, your lordship will kindly come to page 30. The record shows that, first paragraph, page 30. Record shows that Mr. Sitol Barma was 21 years of age and has been produced before this court. On interaction, she has stated that she is 21 years of age and has voluntarily left her paternal home. The relief sought in the petition is for custody of an adult daughter. The concept
It has been rejected.
rejected, your lordship. Now,
Then?
your lordship, and thereafter, your lordship, what has happened, your lordship may kindly come to page 32. When she was brought, the police brought her to the police station, your lordship. At that point of time, she did not want to go with the police and her family members, your lordship. Then, your lordship, they asked me to, your lordship, lodge a complaint before the learned trial court, your lordship. Accordingly, on instruction, we have lodged this complaint, your lordship, against the police officers for forcibly taking her, your lordship.
Police officers took the lady
Lord,
to the police station
lordship.
from the after recovery.
Recovery. She wanted to go to with his
With her
boy,
husband.
your lordship.
Oh, with
Yes, boy, your lordship.
Huh.
Now, this complaint we have lodged before the learned trial court, your lordship, and learned trial court issued an explanation, your lordship, asking the officer in charge to reply. Then what they did, your lordship, in the meanwhile, page 40, your lordship will find an affidavit by the girl, your lordship, where she has said, your lordship, not against us, against the boy, that para 5 and 6, your lordship may kindly see of this affidavit.
Okay. He understood.
Lord.
He surrendered.
Lord, then your lordship, police what they did, page 46, your lordship will kindly see. Submitted an enquiry report and it was registered as an FIR, your lordship. Subsequently, your lordship, may I read this, your lordship? Here, your lordship, our name appeared for the first time. And that too, the other one, my wife, your lordship. Second paragraph onwards, your lordship. During the course of enquiry, I visited the place of occurrence and examined the complaint and other relevant persons. Upon enquiry, it was found that Ms. Sitol Barma was lured by Selimuddin with a promise of marriage without converting her religion to Islam, and under tremendous emotional pressure to marry her, failing which he threatened to commit suicide, and finally was bound to go with him on 23 to 26. But he forced her to convert her religion into Islam.
Just a minute. Tell us one thing.
Lord,
Allegation down below is that they had restrained the lady within the police campus itself, police
Lord,
station campus itself.
Lordship.
Why were they not arrested right then and there?
Lordship, that's your lordship. That is the question, your lordship.
Yes, sir.
And in fact, your lordship, what had happened ultimately, boy and girl, your lordship, now living happily in Bukakhat, your lordship, as a husband and wife, your lordship. Now we are, your lordship,
Yes.
has to face this. We have filed an additional affidavit also to that effect, your lordship.
It has been now charge sheeted.
Now charge sheeted. And this is precisely because, your lordship, we filed that complaint, your lordship. This is the counterblast of that complaint, your lordship. Nothing more than that, your lordship.
Mr. Goswami.
Yes.
Lawyers who are trying, they are lawyers.
Lawyers,
They are lawyers.
practicing lawyers in the Bukakhat.
Both are
Both are lawyers.
there.
And they are restraining a young lady inside the police station, and the police sit down and let them do it. Then they can take the person to the magistrate. Magistrate says, no, let her go home. Yes?
That is the allegation.
And then these advocates also go home. Now suddenly the police says, no, they had restrained that lady. They should be punished. Anything in the maps.
Sheet may be called for, madam.
Huh?
Sir, sheet may be called with this.
Charge sheet may be called for.
Sir,
No interim as of now.
Lordship?
No interim.
No, your
No,
lordship.
it was not.
That's it.
On that part, it was not given.
Yes? You have the case diary?
No, madam, it is charge sheet, madam, then it has to come from the trial.
Heard Mr. S. Bothakur, learned counsel appearing for the petitioner, also heard learned APP, Mr. MP Goswami. Yes. The learned senior counsel, Mr. Bothakur, has submitted, Mr. Bothakur assisted by Likhibo. Mr. Bothakur has submitted that the case has culminated in a charge sheet.
Yes.
Being CS number?
Your lordship, that I have annexed, your lordship. in
Case
addition
number
to the-
63
Yeah.
of 20, case number 63 of the 26,
Dated?
dated 31/5/2020.
2026. Full stop. The call for a scan copy of the TCR. Full stop. Till the next date of listing. Further proceedings before the learned trial court in connection with the aforesaid TCR shall remain, aforesaid CS shall remain stayed.
Close, deeply approved. PRC number, your lordship, 81 of 2020.
It is now a charge sheet number, sir.
No, PRC case has been registered, your lordship. At the page 57. your
Charge sheet number so and so. And PRC case number 81 of 2026.
Deeply obliged.
No. List again on 25th of September 2026.
Deeply.
This is September. Bill hearing, an admission. 79.
Lordship,
Yes, madam.
I'm the petitioner mother in this case,
Ah.
and I'm accused of abusing my baby. Okay, and Lordship, I stay in Dibrugarh.
Ah.
Yesterday at 8:30 PM, I was aware that this matter is listed for today.
Ah.
So I traveled today morning and somehow I reached. Then when I came here, I came to know this matter was mentioned for 2 PM. I was not aware that this matter was mentioned.
Okay.
Now, the thing is, Lordship, I want to make few submissions and end up with a prayer so that the Honorable Court allows it.
Yes.
Lordship, there was an FIR.
You had a list of consuls, madam. What happened to them? None appearing for you today?
Lordship, Saiwala sir was really appearing for me and he was very kind with me.
Yeah.
But somehow now I started feeling hesitant to take more favors from him.
Where is the FIR?
Lordship, I'm so sorry. The brief is not with me right now.
Okay.
Sir, Lordship, the FIR.
Page 108. No,
Lordship,
you make a submission, so listen.
Lordship, the FIR,
Hmm.
it doesn't have the time of occurrence, the date of occurrence, and most importantly, the place of occurrence.
Okay.
We were always, if we go with the allegations, we were always in Bengal. We were not in Assam. So I don't know, Lordship, I'm a layman. I'm just giving a submission because I want to end up with a prayer.
Hmm.
First thing, Lordship. And most important, Lordship, the first, a complaint letter was given by my husband. My husband gave a complaint letter to the Child Welfare Committee. Now, the husband's conduct and reliability. He is under, there are around 10 arrest warrants against him all over India. I am not involved in that. He is in Varanasi right now. The Varanasi District Court has rejected his anticipatory bail. And in the anticipatory bail rejection, it is written that his crime should be punished for 10 years. And he has got 14 criminal cases against him. Lordship, I have no criminal history. Now, this is the complaint letter, conduct of the person who gave the complaint letter. Now, let's go to the Child Welfare Committee. Lordship, when I gave them the warrant, copies of the warrant and the district judge anticipatory bail rejection order, I got a reply from the CWC, which was very, very important for me to place on record. They said the complainant was Gitimilika Gogoi. Now she is no more a part of Child Welfare Committee. They gave me this reply. Lordship, now let's come. Lordship, these are not placed on record. These are, Lordship, recent
Let me
developments.
just ask him one thing. Where is the FIR?
108, your lordship.
Page 108.
108. May I just point out one order, if your lordship would?
Later on.
Okay, first let me,
Later on, we just first want to, 108 is what?
108 of their petition. And your lordship will see the complaint. The FIR begins at 109.
Just let me go through the FIR once.
And the allegations your lordship will find at 112.
That is,
Lordship, I'll
That's
tell you
the
the
Child
allegation.
Welfare Committee.
let me read it.
Because Lordship, since 12th May 2023 till date, those allegations are always in my mind.
How old is the daughter now?
When she went,
No, now.
and now she is 13, she'll be turning 14 or
And where
19.
is she now?
Lordship, I want to tell that, like my husband doesn't have a place of residence.
That
but,
is all right. Where is your daughter now?
now she, at present, she's at Masuri International. But the thing is, presently, I would seek your permission to place on record some orders which shows my husband can be arrested anytime. He can be arrested
No,
anytime.
that is another issue. You want a quashing of this FIR.
Yes,
Your
Lordship.
grievance is that this FIR, no further investigation or criminal proceedings should go ahead.
Yes,
with
Lordship.
court.
Lordship, I want to say one more thing.
Ah.
Like I told you about the CWC, I told you about the conduct of the husband. And the jurisdiction of the FIR lies here or not, I don't know that because we don't know the place of occurrence. If you see the FIR, Lordship, there is no place I have where the occurrences happened because we never stayed in Assam. We were always in Calcutta. I was married in Calcutta, Lordship.
What is the stage of the investigation is over?
Yes, Lordship, the charge sheet was filed within 40 days.
Charge sheet has been filed.
Yes, Lordship.
And what is the stage as of today?
As of now, Lordship, like very
Any witnesses examined?
No, Lordship. ACGM 2 in Dibrugarh, Additional Chief Judicial Magistrate had the matter for trial. When we were, the first Mrs. Gitamilika Gogoi was there for the trial, then suddenly the Honorable Magistrate, he found out that this thing is not fit for the court since it has 75 JJ. So this should be transferred to the district judge. So it is on that stage.
I'm sorry to interfere. May I just draw your lordship's attention to the order of 12th November 2024?
In this
honorable
in
court.
this case, of this court.
Yes, where the 164 statement of the child was called for.
Lordship, I'm coming to that and I wanted to complete
But
to
it's
that.
very important that your lordship sees that.
Lordship, that 160.
You are appearing for whom?
I'm appearing for the husband, respondent number 2.
How is he involved in this case?
He's the
not the
complainant.
No.
Actually, the child called for, the child called was in distress. So the child then informed the father.
How?
Lordship, please allow
Husband,
me to
He
complete.
was then in Banaras.
Madam, we are not deciding the matter today. We are not doing anything to anybody.
Chief, I'm suffering a lot. Around 18 matrimonial cases are going on, and this thing is like a winning trophy for the husband. For every petitions which is going on since 2021, this FIR and this 164 has been placed. Lordship, I'm suffering a lot.
We'll look into that. Let me read it. Which order it?
The order of this honorable.
We are
12th
taking his
November.
assistance only because he knows what we ask for and where is it available. Yes, we are not keeping you down. We are only talking to him because he's a professional who knows how to interact. Yes, we'll go by your merits. Don't worry. Yes.
12th November 24, your lordship, the order. Where at the second paragraph, it's recorded, though the scanned copy of trial code has been received, however, the statement of victim recorded under 164 is not available.
164 statement is there. Have you seen? Kindly see if the 164 statement is available.
Lordship, now the 164 statement.
164 statement is nothing but a first statement made
No,
before a magistrate.
Lordship, 29th
You
March.
don't need to believe it. We don't believe it.
Lordship, 29th March 2023, Supreme Court signed an MOU where I was supposed to take the custody of the child. I was not a monster then. 29th March 2023. Husband has signed. He's happy in his own world with another wife. So, Lordship, I want that whatever I am saying should be recorded. Now, on 4th May, I filed an IA in the Honorable Apex Court because I, being a mother, I thought the child should stay with the father also for some time. Lordship, without any court's order from Delhi Supreme Court Mediation Office, I sent my daughter with the father to spend some time. He took her to a world of Burberry, Louis Vuitton, Apple iPhone, and to Toy Pomerian, Beagle. And I am a poor lady, Lordship. I'm sorry, that is my mistake. I'm a poor lady. When the child came back, now she's not wanting those normal dogs. She's wanting a Toy Pomerian. She's wanting a Beagle. She's wanting iPhone 13, which was not possible for me, Lordship. I am a Samsung lady. Now what happened? This thing is happening. And now, Lordship, you asked a very good question that how did the daughter inform the father? If I am a monster, why will I give a cell phone to the daughter to interact with the father? Why will I give a phone? 29th March, now I filed an IA on 4th May. 12th May, I turned a monster because Supreme Court ordered an Article 142 and to sign a new MOU. And now I turned a monster, Lordship. 16th May, the MOU was to be signed. 12th May, the child was taken away within a span of 4 hours. And now the worst thing is, Lordship, please, it's a request. Don't treat it as an item number. Don't treat it as a case number. My baby is very much in danger because my husband, he has got remarried to a lady from Uttar Pradesh who abuses me like anything.
Your marriage was formally
Registered?
no, and
No, it is
was
not
it dissolved?
divorced. No, it is not dissolved. And I have got evidences for that. I've got papers. That lady, she blackmails me with every single thing, Lordship. If you complain for bigamy, make sure I'll make your child sit in the brothel. If you do this, make sure what I'll do with the child. So, Lordship, please don't treat it as a normal item number. Treat it as a well-being of the child. My baby is in danger, Lordship.
No, this is a petition where you are asking for what? You are praying for what?
We have prayed for two things. We have challenged an order passed by the SDGM, and we have also prayed for quashing. Lordship, I would also like to submit that even my daughter had said against the father, have given a submission, and her signatures are there also.
এইটো এটা কাৰেকশ্যন কৰি ল'ব কমা দা হৈ আছে দিয়ক নেক্সট দিয়ক
Yes.
Service of notice on the respondent number 2. POCSO matter.
Yes.
You want a quashing?
Yes.
How come?
Argo Council out of station, Lordship. Kindly fix on Monday, Lordship.
Huh?
Argo Council out of station, Lordship. Kindly fix on Monday, Lordship.
Okay. List again on 11th of September, awaiting service report on the respondent number 2.
Okay.
Yes, Matter was disposed of
After
by
a
the
long
order
time, after a long time,
Lordship.
you and a white file, yes.
This interlocutory application was filed for that, an order was passed in Lok Adalat, and in that Lok Adalat, this petitioners will appear before the court and they have signed. But when they have gone for verification of the to take the money from the MST court, it shows that the name was written as Josoda Noro, whereas initially it was on Moromi Sinte, and the Aadhaar card was also in the name of Moromi Sinte. But when the father of the applicant given one kotha of land, and he was a Noro, so they have changed the name from Moromi Sinte to Noro. Josoda Noro.
How does the entire name change?
Lordship.
Ah.
Initially, their names were Moromi Sinte. This caste certificate is also there. Aadhaar card is also there. Lordship. In next page.
But sir, tell us one thing. How do we know these are all true facts and these are all it is one and the same person? Can the writ court say so?
No, Lordship. Annexes 13.
No, what we are saying is this. How can I say whether they are one and the same person or not? Is it within my jurisdiction? Someone changes his name or says that I have changed my name.
Lordship.
Am I the person to say that yes, he's the person who has changed the name? So give him whatever money is there. Cannot. There is a particular mode and manner in which a name change has to be declared. Then the money can be released.
That is why I have filed this IL.
I cannot do it. I cannot say that I have gone through the records and I find that Josuda Noro and Mitali Chinte or what?
Moromi Chinte.
Moromi Chinte is one and the same person. How can I declare that?
Lordship.
Not possible on my part. I think a name change has to be first
Gazette, now
by an affidavit, then it has to be
Gazette notification.
on a gazette notification, which has to be placed before the civil court. And there is to be a notice. Then the civil court, if there is no objection raised, the civil court then declares that this is the man, one and the same person. And every entitlement that Chinte had would now come to Noro. That will be the procedure. Okay. I cannot direct this. We'll not dispose this of.
Then we'll carry
Have
out
your instructions on that, if that can be done. But I do not think the writ court or any other court is, other than a civil court is.
This is
because in one particular matter where the lady had changed the name and she wanted a change in the educational certificates, it was later on found that the younger sister was trying to use the certificates of the elder sister who had expired away by changing the name to the elder sister's name. That is one aspect of the matter. Second aspect of the matter is this declaration has to come through the civil court that you are one and the same person. Otherwise, later on in life, it would be a problem of FT.
But they have also filed one affidavit before the bank authority.
It will become a problem for the FT.
Lordship.
Whether you are one and the same person or not. Yes. Where will you get the declaration? That has to come from the civil court. List this matter again on the 30th of September, allowing the 30th of September, full stop. And I get it.
Your Lordship may take it up on some other day convenient because now the fact.
24th of September. Huh?
Yes, you are available.
Yes.
Due to paucity of time, comma. List the matter again on 24th of September for hearing. Mr. B.D. Korn, Learned Senior Counsel, assisted by.
Your Lordship, I think it can be resolved in mediation. Your Lordship may refer it to this mediation. Both the parties we agree. Because they are all neighbors in the same locality of a Mohila Samiti.
What is the allegation?
There was a Mohila Samiti. They had purchased some grant was there. There was sanction was there. They have utilized this money. They have given the accounts and all. And now it's a stale matter. It is of 2001, 11, 12 period, I think. I think these are neighbors, my lord.
There is an
they-
allegation of cheating and fraud, your lordship, in this matter.
Regarding a sewing school to be set up.
They have told we have made a house building so and so, but nothing was
Ego.
there, no construction.
You
nothing.
were also a part of the Mohila Good.
No.
Husband.
I was,
Husband.
I was a person of the society. So
Husband.
I complained. regarding
Go for a
this.
mediation.
Yes, sir. I think that these
Huh?
are neighbors.
As a
Should you?
lordship permits.
Oh, no, I have to have your consent, sir.
They can-
Mediation is never pressurized.
Yes.
But they can go for
Mediation
it.
is
If
only-
something
Huh?
happens there. Yeah, they can go for it. I don't have any problem.
Shake hands. both
Mr.
can go there.
B.D. Pond, on a senior counsel, assisted by Ms. So-and-so, appears for the petitioner. Mr. Your name is, sir?
I am it.
I Ahmed, learned counsel appears for the respondents. Full stop. Respondent two. The counsels have submitted that the parties can be relegated to mediation to make an attempt to sort out the issues. Full stop. Accordingly, the matter be relegated to the mediation center through the registry of this court. I think they have parties should be notified about the date of mediation, upon which the parties should be at liberty to attend the same and attempt a mediation.
interim order passed earlier.
In-time order passed earlier
Shall
continue till then.
We are declared.
Obliged.
Township, I'm appealing for respondent number 2. The conducting council here to give due to some urgency, if the matter could be taken up on some other.
What is the amount?
Lordship, 6 lakhs something is there.
Huh?
6 lakhs something.
Why don't you shake hands and finish it? Huh?
Today, he said that in short, that will fix.
Concurrent findings,
No,
two
Lord,
cases.
no concurrent findings. It's only against the trial court order.
Huh?
Against the trial court order. Only against, it is appeal against acquittal laws. Not
Oh.
a revision laws.
Appeal against acquittal. Acquittal, oh. When?
Lordship, I am aware, convenient to a
We are adjourning at his convenience. We will fix it at your convenience. Yes, when?
I am available, Lordship.
We'll keep it on 22nd of September, 2026. List again on 22nd of September at the request of the learned counsel for the respondents.
Number 2.
Respondent number 2.
73 is also there, also my case. Item 73 also.
This is item 71. Wait for 2
Lordship.
seconds, we are going and yes, 71.
Yeah, please, Your Lordship. Lordship, I am the respondent in this case and, oh, sorry.
Hmm.
Lordship, I usually stand on that side. Lordship, I am the respondent in this case and an amount of rupees 3,72,000 is to be paid to me as per the order passed by the learned session judge Barpeta.
Not paid till now.
Not paid till now. And this
No
is a-
stay.
No stay. And even I have not received the interim compensation that should have been paid to me at the time of pendency of appeal.
These are things you raise in the lower court. There is no stay here. Why don't you go and do it in the trial court?
That has not been raised,
Huh?
Your Lordship, and now this prayer for setting aside that particular judgment, that should not be entertained. That is,
We don't know. In his absence, we don't want to dismiss. None appears for the petitioner on call. Miss L. Bonik appears for the respondent number 2. Full stop. It is noticed that there is no stay granted in the present case, and yet the learned counsel for the respondent number 2 has submitted that the petitioner, that the respondent number 2 has not been benefited by the orders passed by the passed by the trial court
learned session judge of Barpeta.
and the appellate court. Full stop. List the matter again on 17th of September 2026. Full stop. It is noted that in the absence of the representation on part of the petitioner, the matter would be dismissed.
72.
Yes, sir.
Lordship, today,
Huh?
today, Lordship,
Today is not a good day.
note for that, Lordship, almost time is over. Lordship, initially case of outraging of modesty of a girl, Lordship, but subsequently at the stage of argument stage, case was again relegated to the POCSO court for framing a fresh charge and including POCSO.
Naturally,
Lordship, but it is not a case of Lordship POCSO actually.
the victim is 5.5 years old,
No,
10 years, 2 months.
16 years old.
no, not for that. Allegation, Lordship kindly have it. It is allegation only outrage of her modesty.
What more do you need?
Outrage of modesty.
Outrage of modesty is for an adult.
Lordship,
POCSO is for the child.
Lordship, but outrage of modesty, there is a 354. Police investigated the case.
Outraging the modesty of a what? Of a woman.
Lordship, but there is no section 8 is not.
What do you say, sir? We should acquit him? No. Then
Lordship,
sufficient.
Lordship, but sufficient, but there is no allegation against one.
If you argue more today, he will say it is more than sufficient.
No, that is not correct. I will satisfy your Lordship. There is no specific allegation against accused number 1.
Identified both the accused person in the court.
Maybe, but vague allegation. Lordship, kindly have a look at the Azahar.
You said there is no time today and we are arguing the matter and hearing it. Is it not? There is always time. Huh?
Maybe on third, Lordship.
No, September 1st, 2nd week, nothing doing. 17th.
Lordship, this case may be listed in the orders column for consideration of bail. Already 1 year, more than 1 year, Lordship. In
What is the punishment given?
5 years, Lordship. Maximum period 5 years. Maximum 5 years. So, Lordship may consider this that.
List again on the 17th of September for hearing. Full stop. In the event the hearing cannot be taken up, the prayer for suspending the sentence awarded in the impugned judgment shall be considered.
All right.
Yes.
Lordship. Same, this is also against acquittal, Lordship. May fix another date.
List again on the 23rd of September.
23rd, Lordship.
23rd.
23rd of September. Narrows.
Pertaining to item number 71,
Ah.
can the date be adjusted to just 1 day after that? Was fixed 17. I am seeking for 18th of
18,
September.
18 kori di?
Highly of it.
Yes.